Good afternoon to everyone present today at the public hearing held by Panel B of the Prosecutor's Vetting Commission. I am Virginia Moraru, Deputy Chair of the Commission and Chair of Panel B, and I hereby call this session to order. The Prosecutor's Vetting Commission was established and it exercises its powers in accordance with the provisions of the Law number 252 passed by the Parliament of the Republic of Moldova in 2023 on the external evaluation of judges and prosecutors, and also amending some regulatory documents. Thus, this law explicitly provides that this commission shall assess the ethical and financial integrity of prosecutors who are referred to in Article 3, Paragraph 1 of the aforementioned law as subjects of the evaluation. The panel conducting this hearing consists of 3 members and was established to evaluate the subjects in accordance with the provisions of Article 15 of the Law number 252 on the 31st of May 2024. I am joined here by the members of the Panel B in this room, Cornel Bedinsky, national member, and by video conference joining us, international member, Irmantas Mikelionis. The subject of today's hearing is Alexandru Gaina, prosecutor with the Anti-Corruption Prosecutor's Office, who is being evaluated pursuant to the aforementioned law, Article 3, subparagraph 1E and paragraph 3 of that law. Good afternoon and welcome to today's hearing. The hearing is carried out in accordance with Article 16 of the aforementioned law and the Commission's rules of procedure. Throughout the evaluation of the subject and during today's hearing, the panel is being assisted by members of the Secretariat. Also, this hearing is open to the public and the media, and anyone who would like to participate and is carried out with simultaneous Romanian and English interpretation. Therefore, all of those who will be taking the floor are kindly asked to speak slowly and clearly to allow for accurate interpretation. In compliance with Article 16, paragraphs 3 and 4 of the aforementioned law, the hearing is recorded by audio and video, and the recordings of the hearing shall be posted on the Commission's official website no later than 3 days after the date of the hearing. Mr. Gaina, at the end of the hearing, you'll be given the opportunity to deliver some closing remarks if you so wish. But I will begin with a brief summary of the evaluation of Mr. Gaina. The Commission initiated the evaluation of the subject on the 24th of May 2024 by notifying him by email and requesting that he fill out and submit to the Commission a declaration of assets and personal interests for the past 5 years, which includes a list of close people working in the judiciary, the prosecution service, and the civil service, as well as a questionnaire regarding ethical integrity, as set out in Article 12, paragraphs 3 and 4 of the aforementioned law. The prosecutor has submitted to the Commission the requested documents that were filled out, signed, and accompanied by the required attachments by the set line on June 13, 2024. Furthermore, in accordance with Article 12, paragraph 5 of the law mentioned above, by submitting the statements, declarations, and the questionnaire mentioned above, the subject of the evaluation declares under their own responsibility the accuracy and completeness of the information provided and consents to the processing of personal data. Following the random assignment of the evaluation file to the Commission's evaluation panels in accordance with the procedure set out in Article 17 of the Commission's Rules of Procedure, the evaluation file concerning Alexandru Gaina was assigned to Panel B in its current composition. On the 16th of August 2024, Mr. Gaina was informed by email of this fact, including of his right to request the recusal of members and the conditions set out in Article 10 of the Commission's rules. Mr. Gaina did not request the recusal of any Commission member during the evaluation. Also, during the evaluation, the Commission has requested and gathered information regarding the subject and people close to him in order to determine the subject's compliance with the ethical and financial integrity criteria as set out in Article 11 of the Law 252. In this regard, the Commission has obtained information from multiple sources, such as the National Integrity Authority, the General Office, the Office of the Prosecutor General, the Ministry of Interior, Superior Coastal Prosecutors, Customs Service, and other public authorities and institutions, as well as private entities, including financial and banking institutions, and open sources have also been looked into. The panel has analyzed and assessed the collected information in terms of accuracy and relevance. With regards to the issues and uncertainties identified during the evaluation process in the information collected as mentioned above and in the documents submitted by the subject and answers provided during the Q&A rounds, the panel has asked some follow-up questions and requested additional information and supporting documentation. In this regard, the subject has responded to 4 rounds of follow-up questions on the 13th of November 2025, the 6th of January 2026, the 25th of February 2020, 23rd of March 2026, and 21st of May this year. This subject has responded, except for those rounds for which it asked for an extension. It answered by the deadlines, and to a great extent, it submitted the requested documentation. According to the provisions of Article 16, Paragraph 1 of the law, and Article 28, Paragraph 3 of the rules of the Commission, if, based on its investigations regarding the subject's compliance with the integrity criteria, the panel or the Commission has doubts, then the panel or the Commission shall send the subject a written notice setting forth all of the panel's or Commission's doubts and shall schedule a hearing at least 10 days after the date of such a notice in order to talk them out. If the subject refuses to participate in the hearing, the panel or the Commission shall finalize the evaluation on the basis of the information it will have collected without having carried out a hearing. On the 6th of July this year, Panel B has notified the subject that it had completed the evaluation and that it identified some issues, some doubts with regards to the financial integrity of the subject, which would be discussed in a hearing, and invited thus the subject to participate in the hearing scheduled for today. Mr. Gaina has confirmed receipt of the notification on the 8th of July and confirmed his participation in the hearing. He has also requested by that message 2 items. The first request was to hold a hearing in a closed session in camera. This request was denied, and the decision issued in this regard on the 8th of July was communicated to the subject on that same date. Now, Mr. Gaina would like to reiterate item 14 of the decision that you have received, and that is, if during the hearing specific circumstances arise which, in the subject's opinion, your opinion, require protection for concrete and compelling reasons falling under Article 16, Paragraph 3, Superscript 1 of the Law 252, then you may file a request at that time in that regard. To review the request, the panel will hear the subject's, yours, arguments in a closed session. Following the review, and if justified and proportionate, the panel may decide that a specific portion of the hearing be conducted in a closed session. Is this explanation clear to you? And the second request that came from the prosecutor was the request to hear the evaluator Gennady Grosso during the hearing scheduled for the 17th of July this year, that is for today, and the panel, by claiming Article 16, Paragraph 7 of the Law 252, unanimously decided to grant the request to hold the hearing of the evaluator Gennady Grosso. Concurrently, the panel has emphasized in its response that ensuring Gennady Grosso's presence is the responsibility of the subject, and the evaluator's failure to appear will not prevent the hearing from taking place. The prosecutor has also requested access to the evaluation file. On the 10th of July this year, the Secretariat presented and made available to the subject the evaluation file in accordance with the provisions set out in Article 28, Paragraph 4 of the Commission's Rules of Procedure. On the 16th of July, Mr. Gaina submitted to the panel a document titled Statement of the Evaluation Subject Alexandru Gaina with regards to the doubts identified by the Commission as set forth in the annex to the hearing notice number 48 of July 6th, 2026, and a second document that was called Explanations of the aforementioned evaluator. Now, Mr. Gaina, since you've submitted the documents only yesterday, the panel did not have sufficient time, given the little time available, to review them, but you have the possibility to bring them up in today's hearing, and after the hearing, of course, we will have a look at them as the panel, and if additional questions arise from us, we will ask them in the same fashion as we did previously, as the entire correspondence was so far. Mr. Gaina, based on the above, and before we move on to the second part of the hearing, that is, I would like to ask you two general questions. And the first one is whether you would like to make any additions or changes to the answers or information previously presented to the Commission during the Q&A rounds or to the documents submitted. Use the microphone, please. Esteemed members of the Commission, currently note if the evaluator is heard that I have no need to provide anything further even regarding the explanation, but the evaluator is available here as far as I noticed. And the second question, are the answers you provided during the Q&A rounds as well as the information put down in the 5-year declaration and the ethical integrity questionnaire, are they still accurate and up to date as of today? Yes, no changes have occurred and no corrections to be performed. Understood. Thank you. Next, we will discuss those issues that were set forth in the annex to the hearing notice, that is the doubts of the panel that you have been made aware of. And to avoid infringement upon the rights and legitimate interests of third parties, I would like to ask all speakers to refrain from using personal data with regards to third parties that would otherwise be identifiable. And thus, in this regard, I will pass the floor over to Irmantas Mikelionis, who will be the one addressing the first matters and questions to you. Apologies, but please use the microphone. When you do anything you want to say, you have to use a microphone for. I have a request before we move on to the hearing, first to hear the evaluator, because we don't know how long this will take, how long my hearing will take, but the evaluator is available here. Understood. The evaluator is already here. Yes, that is my understanding. Then we shall take a technical break of a couple of minutes. We'll have a discussion. The panel, that is, will deliberate for a couple of minutes, and we will let you know about how we go about this. Thank you.
The panel is back with the hearing. We have in the room Prosecutor Alexandru Gaina of the Anti-Corruption Prosecutor's Office and the witness whose presence was requested by the prosecutor, Mr. Gennady Grosu, evaluator who provided 2 evaluation reports during the evaluation of the prosecutor. Mr. Grosu, please provide an ID so that we can make sure that you are the person you claim to be. Thank you. Having analyzed the request of the prosecutor, the panel deliberated and decided to accept the request made during the hearing. So we will first hear Mr. Grosu. To this end, the panel and the prosecutor will be asking clarification questions related to the doubts that the panel found. Mr. Mikelionis, you have the floor.
Thank you. So maybe I will ask my questions later. So I suggest to give the floor to evaluator, first of all, for his explanation regarding evaluation report.
Okay.
Dacă permiteți, doamna președinte.
If I may, Chairperson, welcome to the hearing of our Commission. We have some questions to you, not as much as a witness, but as to a person who is licensed in evaluation of real estate, constructions, land plots, and questions about the veracity of the information that you provided to the Commission, whether it corresponds to the status that you have. Your identity was confirmed. Please confirm that you have a license and at what level of authorization that license of yours is. I am Gennady Grosu. I am licensed. I have been a licensed evaluator since 2003 to this day. Over the years, every 5 years actually, we have to pass an exam to extend the validity of our license. And I'm also a judicial expert at the criminalistic center of the Ministry of Justice. Please, I understand. Please confirm that at the time of the valuation and issuance of the valuation report, your license was valid and registered at the appropriate level of authorities. The license is valid until 2028. Thank you. Next question. We are not going to share data, but we know what we talk about by the name, your name and signature. You put the stamp of a legal entity in the reports that you issued. And I wanted to ask you, is the company, that legal entity whose stamp you put, does it have in its registered activities, does it have the right to carry out such an activity as real estate valuation? I have two companies that are registered in my name, and in both I am evaluator and administrator. The first company, the older one, around 2003, the Chamber of Licensing issued a license for the activity of legal entities in the presence of evaluator. That moment of licensing was annulled, if I'm not mistaken, in 2013 or 2014. And since 2014 to this day, the license for legal entities for valuation of real estate and technological equipment is not being issued anymore. The activity of legal entities currently takes place based on the valuator certificate that is valid. In the decision or in the activity of a legal entity that developed the valuation reports, if I'm not mistaken, I forgot now the name. The type of activity, purely real estate valuation, there is no such activity at the Public Services Agency. This is assigned to sub-activities, and in the list of activities for legal entities, it is for the activity of real estate valuation. Okay, thank you. Next question. In your report, you mentioned that as part of evaluation and report development, you did not visit the real estate on-site physically. Could you please inform the panel what was the rationale and why did you proceed like that? Given that, in order to determine the past market value from 2013 to this date, that real estate was subjected, according to Mr. Alexandru, it was repaired and people are living there. So there is no reason, well, that's not right, but it will not, the current status will not give us any information about the situation in 2013. Last question. When assessing the price, tell us, please, based on what methodology did you act? And did you have such valuation cases in the past? In the valuation reports, two approaches were applied: market-based and cost-based approach. The market-based approach is an analysis of real estate offered for sale in different periods of time. In this case, if strictly on the date for which the evaluation is asked for, every evaluator has an archive. I work since 2003, so you understand we have a rich archive. We analyze real estate from such standpoints as location, useful area, area of the land plot related to that real estate, the condition, and the improvements. In this report, several periods were found. It's used what they say fraction of adjustments, and we make adjustments for various periods. You can see in the report if the real estate or the analogy that was found, if it's from another year, not from that the requested year, correction coefficient is applied, and this coefficient is calculated based on statistics. The possibility of individuals to purchase real estate is the salary. In various years, salary has been increased since 2003 to this date. It has increased, and it relied on statistics in order to determine how much the real estate that today's real estate would cost in the past. That is one method. Another, or the second approach that was applied, is the cost-based approach. How is that done? First of all, market analysis, past market analysis is done of the real estate, of the land plots with no constructions, and then you add the calculated value based on norms for the real estate in the condition that it was, applying coefficients of statistics coefficients passing from one year to another. Also, there is the final handover document for the house, and based on photographs from that time, the house was not completed at 100%, it was around 87%, if I'm not mistaken. The report states that. So it wasn't calculated for 100% completion degree, even though there was a final handover document. That final handover document is issued when the construction is 100% complete. Thank you. One more clarification question. According to the materials gathered by the panel during the assessment, the buyer of that real estate, incomplete real estate, sold the real estate over years, and looking at the price difference, we mostly know about valuation approaches in Chișinău, but I would like you to tell us, you said you have information since 2003 to this day. Tell us, please, in what region of Moldova you work, for which region of the country you have a database, and how do you explain the price development compared to Chișinău? So what factors influence prices, and how can prices be so close? Because we know that in Chișinău, an apartment sold in 2013, or purchased in 2013, and if you sell it now, the price will be double or triple. So we want to know, we want to have some clarity. How did markets in other regions of the country evolve? Thank you. Based on the, well, with respect to the database or the information base that started in 2003, my activity is all over the Republic of Moldova. I know the market from south to north. Since 2003, I started to work with all commercial banks that are in Chișinău, in Moldova, for crediting because this service, valuation of real estate, was created for mortgaging. And the price growth is not having the same trend as Chișinău does. But in other district centers, since 2020 onwards, the development follows the same pace as in Chișinău. I'm not saying that the prices are the same, but as prices grow in Chișinău, they also grow in developed district centers. That's it. Sorry, we can't hear. I have a few clarification questions, unless Mr. Mikilionis wants to ask questions first, if you have any.
Yes, I have. Thank you, Ms. Chair. So, Mr. Grosso, so according to our knowledge, you provided two evaluation reports for Mr. Gaina. Did Gaina express any expectation regarding the estimated value of the property before or during the evaluation?
I'm not sure I understand the question.
Please repeat encore.
Okay, so you provided two evaluations reports to Mr. Gaina. My question is, did Mr. Gaina express any expectations regarding the estimated value of the property before or during the evaluation of this property?
Now I understand. No, we are not working in such a way. Unfortunately, actually, fortunately, no one can influence us in the decisions that we state in our evaluation report. I am too old to be influenced.
Thank you. Have you or your companies previously provided professional services to Mr. Gaina or any person related to Mr. Gaina?
No, it was the first time now that I provided these two reports.
Thank you. Are you aware of any circumstances that could give rise to doubts regarding your independence or impartiality in performing these evaluations?
No. Should I understand that there could... Are you asking if there is something that could have influenced me? No.
Yes, in general. And question regarding remuneration. So I am not asking about the concrete price of these services, but my question is, was your remuneration for the evaluation agreed independently of the evaluation outcome?
Sorry, I didn't hear the second part of your question.
Was your remuneration for the evaluation agreed independently of the evaluation outcome?
Yes, it is independent, and the tariffs are the same tariffs that the company provides to every client, because the tariffs are fixed at the beginning of the year. That is based on the economic situation in the country.
Thank you. What is the estimated margin of uncertainty or error associated with your evaluation?
If you pay attention to the reports in In the valuation report for the real estate of 2013, two methods are applied. In these two methods, the figures, the market values, are approximately the same. In this case, yes, every evaluator has a margin. Meaning that if several evaluators do evaluation of a real estate today, the difference from a person to another could be 10% maximum. It could be plus 10, minus 10. This is a margin that is allowed among evaluators when you establish the market value.
Thank you. What documents were provided to you by Mr. Gaina for the valuation properties? You already mentioned that you had photos of the property. What else was provided for you?
He provided ownership documents from that period of time and the owner's ID, the technical file that is issued only by the territorial cadastral body, which has to be kept in the archive after the house is put into operation. So the real estate is registered with the territorial cadastral body.
And my last question what is your possible liability as a property value for carrying out acknowledging incorrect valuation of the property?
Sorry, please repeat it. The connection is poor.
What is your possible liability as a property value for carrying out knowledgeably incorrect valuation of the property?
According to the Criminal Code, Article 311. That's Article 312, criminal liability for... That's false statements, false testimony.
And last questions, are you covered by professional indemnity insurance?
No, we are not insured. The law does not... Well, there is no evaluator that's insured. No criminalistic experts are insured.
Thank you, and no more questions from my side.
Okay, thanks, Mr. Michelanis.
Mr. Grosso, I have a few clarification questions as well. I want us to discuss about one of the reports. You provided the subject with two reports about two real estates, and all the questions are mostly related to the report regarding the real estate, the house, the unfinished house. You answered several questions, but I have some questions that are more or less close to the questions you have already answered, but they are for clarification for me. The prosecutor asked you to carry out this valuation and provided you for both assets, for the first and second report, certain information that he had available. This information, for us to understand, are underlying the report, besides the methodology and other things that you as a professional are applying in the valuation. I'm interested. When you received the request, including all information, the information that the prosecutor offered you, did you believe that information was enough and you did not ask for any additional documents or information, regardless of what was provided to you at the moment when making the request for evaluation? So, from what you mentioned in the report, it's mostly about cadastral papers, and that's it. that was provided by him. So did you believe these documents were enough for you to carry out a retroactive evaluation? And in this case, it's more than 10 years ago. That is the first question, and then I will continue. Thank you. During the evaluation process, all evaluators are obliged to ask first of all, to ask for ownership documents, including for separate constructions. We are asking the technical inventory file to determine the volume of constructions, the materials that were used to build the real estate, what is the ground area that is checked against the abstract from the cadastre, what's the internal useful area, because these are two areas that differ. So in the abstract from the real estate, they show the ground surface on ground, but since this house or the house could be 2-3 stories, the internal useful area is only in the technical file. That is about one report. We only talk about the report about the real estate with a certain degree of completion. The ones that was not 100% complete. In the report with that was incomplete real estate, the evaluator, according to the law, is obliged to apply only one method, one approach, the cost-based approach. Given that that construction was not completed and there's an inspection document from territorial cadastral officers who registered that the construction had 80-something% complete, in this case, you can't apply another method for evaluation because such incomplete properties we can find only in Chisinau. Information about incomplete real estate. In other district center, the market is not that developed. I understand. You, at that moment, did you ask the request any clarification questions or requests, or did you just accept what he provided? About the incomplete construction, the information that was registered with cadastre was enough. Now, of course, it could have been demolished. Something else could be built by now on that place. Given that we only use one approach, the cost-based approach, we only rely on the documents that are submitted, what is registered at a specific point in time, volume of construction area, so on, that's all. With respect to the object that was finished, in that protocol, I asked for photographs in order to determine, indeed, for the date for which evaluation was asked, what the condition was. I needed to have a vision how the real estate looked like at the time of transaction. That's it. I understand. It is quite difficult, I presume, for you as well. And for us, it is much more difficult to ascertain some aspects that could be in favor to the disadvantage of the subject that is being evaluated. That's why I want you to understand that all the clarifications that we're asking for is not to accuse you that you did not do your job properly or as the law requests. We don't want to accuse the prosecutor of anything. We just want to make sure that our evaluation is as objective as possible. My next question is about the fact that you mentioned that degree of construction completion. Could you tell us in which document that your client provided this was mentioned and that you followed that completion degree? Or did you request, or maybe you decided that you don't need to request anything else? About the incomplete construction, if I'm not mistaken, there is a document, an inspection, on-site inspection. It was attached to the report. with photos, and it states that the completion degree was 80-something%. About the second real estate, about which there was a final handover document, based on the photographs, I determined that if the construction was registered, there is that report of 100% construction completion, but based on the pictures, it wasn't 100%. That's how real estate was being registered before. Going back to a question, you mentioned that you only use the cost-based method because for incomplete goods, you apply only this method. So is this a legal provision, an explicit legal provision? Is it a legal norm that says explicitly that for incomplete constructions, you apply only this valuation method and you can't use other methods? Or you can't use this method and other methods? Yes, this is also part of a loan valuation, and it's also in the standard, the guide, the evaluator's guide. But also it's based on practice. I understand, any evaluator understands that if we have an incomplete construction, to be able to compare it against another incomplete estate, it has to be at least 80% the same structure, location, completion, construction materials that are used. And this is impossible. I understand. I would like to ask you to explain us, why did you believe that the information available provided for the subject, the information about the incomplete real estate, I'm only speaking about that, and what you are using, all of that information is enough to establish the market value of a real estate for the period of more than 10 years ago? There could not be any other documents. To determine the market value, it is enough to have this technical inventory file and or the handover report, or that is examination document that is drafted by state authorities, so before registration. I want to understand these materials or this information that is available to the subject, that the subject provided to you, and the methods that you applied were enough to establish the value of the real estate, or the market value of a real estate in 2013, or there is no difference between these two prices?
The value of the asset of the property, that is the market value of the property. At that time, we could sell that asset for the price that is indicated in the report, with a margin of about 10% plus or minus. And you've mentioned that you've used this method or approach that is cost-based for materials, for the unfinished construction. Is that only down to what aspects of the cost to establish the value? I mean, some details so that you get us right. Your area of work is rather specific, that is different from the work of that we do, or the work of prosecutors, and we need to have a clear understanding. So that's why we want to have more information. So I hope you're not surprised about questions regarding these details. If I'm not mistaken, in 2003, when the law was passed on evaluation, the appraisal, some documents were developed as basic ones for Moldova. All the indicators for real estate appraisal, for constructions that are used for residential purposes. And for every construction that is residential one, is it a one-story or two-story construction with basement? The cost is indicated for 1 cubic meter, as in more or less what the cost would be. And the moment that these coefficients were worked out, they were enforced since back in 1997. and they are looked up when we need to determine the market value of an asset, of a property. And there are some coefficients that are stable that we take from the statistics department depending on the dynamics of the economy. And then there is, for instance, 20% VAT that is added, such a coefficient as well. And there are some coefficients that are related to the indirect expenses and what the benefits are for the investors. So that's how we work around the investment that is made. That is what we factor in when we perform the assessment. So we either look at the extent to which it was completed, and of the total cost we can subtract what there was until the moment of investment. And then we also have wear and tear, that depreciation, the physical one, as in we visually see the real estate condition, the functional one, fractional depreciation, and economic one as well. The economic one is established on the basis of statistics too. That is, calculations that we take regarding the period that the assessment is carried out in, the appraisal is carried out in, and then we reflect that in the report. The investments that are made, for instance, in a particular village, and then the investments that we make in this regard in the center of Chisinau, so that would be 100 lei invested and we sell it for 200 lei, the market value, for instance, and in the village we invest 100 and we sell it for 20. That is the internal, the real estate market. So completely unjustified certain expenses would be in this case. Thank you. But could you tell us if you remember regarding this uncompleted asset, when you've used all of those methods to perform the appraisal, have you also carried out some comparable transactions or transactions that would be compatible to that asset? Maybe looking into your professional experience in this regard, is there anything compatible you could bring up? Have there been any other transactions that you've seen maybe on the internet? You've mentioned that database with information that you have, some similar transactions outside of Chisinau regarding assets that were not completed as well, where for instance, the degree of completion was a particular one. Well, there are two reports, one of 2003 and one of 2013. What is the report we speak of? The 2013 one, the one that was not completed. Regarding the one that was not finished, we've carried out an analysis and we put it down in the report. Prices across different periods of time were mentioned. And as previously mentioned, although there was an uncompleted building, we see it being unfinished, for instance, and we also provide some adjustment coefficients as at the date of the transaction. That's what the report says. And that coefficient is specifically based on statistics. So the price can go up or down depending on that coefficient, and that is the basis. And then constructions, they can be completed, and some adjustment coefficients are applied for the technical condition or the size of the area. It can be 6 Rs or 20. In all of the instances and examples that were provided in the report, well, everywhere we've applied coefficients in order to establish what the price would be of that asset. And considering that, as previously mentioned, the values for the two methods, they are practically identical. According to those two methods, they're practically identical. It's only that, well, the report is genuine. Well, we don't mean and we don't want to blame you of anything, of course. So we just want to gain better clarity. It is the first time that we've come across such a situation when a property appraisal report is delivered for an asset that was held backdated in the past, and then it is established in 2026 that they had the value of an asset in 2013. And so we want to have a clear understanding, and we need to be able to argue the different positions that we have in our report with regards to the prosecutor. And we certainly do not mean to pin anything on you, of course, or to insinuate anything. You've stated that you've been using statistics, but can you tell us what is it that you mean when you say statistics? As in, who has the statistics, and how are you using that? Where are you taking it from, and how do you apply it? So, in the answers you were providing, you stated that you use statistics. So what is that you meant by statistics, and how we ourselves could gain hold of that and maybe use that for our own purposes in other situations? Well, there is Statistica.md, that's the official data of the National Bureau of Statistics. Those are the statistics that we use. So for different periods of time, for different quarter, for every quarter of the year, they publish this information. You can look it up on their website. There is all of the information that I used, which is specifically where I took data for the adjustment coefficients. It's that data that I used. I mean, they're not my own statistics. It's the government statistics. Understood. I was thinking of what type of statistics was that? Was it sold property? Was it assets that were constructed or built to a particular level of completion? It's a cost-based approach, which implies the application of a coefficient. And that is, you use a coefficient, an adjustment coefficient. I stated that in 1997 the aggregated indices were developed. And for us to adjust the information to now, we use statistics information. How much did the prices go up in constructions, for instance? To establish that as of the date of the transaction, we use statistics with regards to the average wage on the market in that area where the asset is located. So we use very simple formulae. I mean, it's really nothing out of the ordinary. It's nothing out of the ordinary for you, but quite complicated for us to grasp these formulae. You've mentioned that when the different methods of assessment, of appraisal are applied, still there is some sort of an error margin. How do you calculate it? This error that could support or otherwise the certainty of an appraiser regarding the price. I mean, obviously, this is not guaranteed 100% that there was that particular precise amount that was mentioned. But this certainty or lack thereof regarding the price, how can that be affected? To what extent can it be affected by error? I mean error, not the human error, but as in the value of the appraisal. All of the appraisers, when they establish the market value, they, as the law says, they have to establish the market value of a real estate asset as at a particular date on which it could be sold. That is, in this exercise of appraisal, there is a risk margin as well. The property, if it is put up on the market, the appraiser shall calculate the market value looking over a time span of half a year, and half a year from now we'll be selling it for this price. If the sale is to happen very soon, then that is done on the basis of a so-called liquidation value, and the difference between them, 10 to 30% minus. Again, the reason why I'm saying 10 to 30, that is depending on what asset that is. If it's an apartment that we can sell it fast with a smaller area, then this forced sale coefficient is a particular one for the need to sell it sooner. If it's 500 square meters, and we know very well that it would take us some time if we take only 10% of that, we won't be able to sell it even in half a year. So then the coefficient would be bigger depending on the area of the asset, where it is located, and the condition it is in. But for instance, just as any other matter, out of what you've mentioned, the materials that were used for building the asset, they too can be of different quality categories. If, for instance, they use materials from a different construction that was demolished, leftovers from a demolished building. It can happen. Then, is the error margin affected? Does it have an impact on the value of the asset? Have you found this in your practice? Have you come across this? Well, we look at an asset from inside and the outside, that is finalized, completed constructions. If there was plaster inside and outside, we cannot establish what was there inside. Maybe there was cheaper construction material, or maybe there wasn't. We don't know that, and nobody can say that. Only if, like, an expert review is carried out to establish the condition of the particular building. The appraiser establishes the condition of the construction visually, by visual inspection. We do not apply methods as in breaking down a wall, for instance, to see, to look inside that wall. That's as far as that particular expert review is concerned. Yes, but have you asked the applicants, considering that out of what you told us, you did not inspect personally the property, given that it was no longer the property of the prosecutor or people close to him? Have you talked, though, about the materials used to gain better clarity, or did you just follow the information provided and the documents that were provided by the prosecutor? When it comes to the condition of the asset and the materials used for the construction of the property, well, in that regard, there are documents that specifically, explicitly state what materials that is made of, and that is sufficient for me. If the foundation has concrete, well, it's concrete. If the walls are made out of limestone, then that is that. I mean, if there's no plaster whatsoever, then that would also influence the price. However, considering that the level of completion was about 80-something%, if I'm not mistaken, that is, there's already plaster. Now a question, since you've mentioned it, is it possible to look at the pictures and tell the difference, meaning the different types of plaster, if they use cement or sand or something that is more modern, and the method of plastering that used to be applied in the back with straw and some other materials that are no longer used, such as clay. I mean, looking at the pictures, you could tell where that is the case, so where there is clay and straw, or whatever other material, gypsum, for instance. Sometimes they can differ. I mean, people are different, have different ideas. They can establish some panels made of gypsum. They install it like that, and they add just a thin layer of something just to work around it. I have a couple of questions, but I don't want you to take it personally, and it's not meant to affect your professionalism in any way. But do you think that, for instance, a different appraiser, do you think they would do exactly what you did regarding the assessment of those properties? Or do you think that a different appraiser would use other tools in the general meaning of the word? Do you think another appraiser would use other data, other information, would do things in a different way than you did it, or would they do it the same way that you did, in terms of the methodology applied by property appraisers? There are two methods. For residential real estate, detached houses, only two methods are applied. Every appraiser has information: the cadastre, and what is registered with the cadastre, the ownership documentation, the ID, and the physical condition. If it's in retrospective, then we use the pictures that will have been made available. Out of the pictures, you can see that it's not an old building, that it was built rather recently. And as for other information, other methodologies, but these two, there aren't any other methods. Yet in the cadastral documentation, there is an amount that is put down that is different than the one that you have provided in the appraisal documentation. And the difference is quite sizable, just to be certain. What do you think? Where is that difference coming from? There are two appraisal amounts linked to an uncompleted asset. Why is that the case? As for the cadastral authority on the territory of Moldova, they establish the market value according to cadastral rules for taxation purposes. In this case, for taxation purposes, the value for taxation is different, is indeed very different from the market value. And let me provide an example. Until that year when the appraisal of assets was performed in Moldova, that is, until that time, it used to be like this. An apartment in Chisinau with a market value of about 100,000 euros in the cadastral records, it would have the value of 220,000 lei. That is the value subject to taxation. And as owners of such assets, we pay real estate taxes on the basis of that value for taxation purposes. I mean, we know, we are aware of that the cadastral value is established for real estate taxes to be levied, to be collected. Still, the method to appraise the value of an asset by the cadastre, well, is that method that much different from the methods applied by the independent appraisers? Until not long ago, the cadastral authority wouldn't apply the market approach to establish the value. They would strictly use the aggregated indices and that statistics coefficient. Since 1997 till the time that the assessment is carried out, that transfer coefficients, and there would be a normative price for the value of land. So altogether, it would mean that it's just that how they were doing those calculations at those times. But starting with January 1st this year, a reappraisal endeavor was initiated for all the residential constructions in Moldova. Now the market value is used. The appraisers, not the cadastral authority, the appraisers are providing such services and make the calculations as per the actual market value. Understood. But can you tell me on the basis of the report that you have submitted to the subject that was then forwarded to us, there is a conclusion where it is stated what the value of the asset was, and that is whether a finding, and I mean from legal point of view, from this, well, is it a finding or is it the opinion of a professional? What it would rather be? That is the value, the market value in all reports, that's the opinion of the appraiser. It can be different, more or less, as I previously stated. So I believe this is the price. I mean, the calculated price determined on the basis of appraisal methods. But the owner, they may say that, well, I don't want to sell it for 100 lei. I want to sell it for 120. For instance, I mean, nobody can impose, cannot tell them. This doesn't mean that this is the last price that is set in stone and that one must not deviate from. That is a suggestion, or stating that the market value of this asset at this given time is this. And then it's up to the owner to decide to sell it for more or for less. Understood. It was a matter of principle to understand that, because most of us here are lawyers. And we know that a finding is one thing and an opinion is something else. And we wanted to know what is the category of the reports that you provide, and to more or less figure it better out how to address it. Thank you very much, Mr. Gross. I have no other questions. I'm looking at my colleagues if they have any. I have a question regarding the last appraisal. You stated that you had a broad collaboration with the banking institutions of Moldova. Now, just for information, it's not mandatory for an individual, but we know that banks use appraisal reports as a reference for giving out loans. That is it mandatory for banks Or is it just a document of collaboration, so to speak? Just to understand what the force of such a report is, as the one that you've issued. The appraisal reports for banks, it's mandatory for the bank. It is the obligation of the bank to secure the loans given to people. But in the appraisal reports developed for banks, there are three values: the market value, the liquidation value, and replacement value. The replacement value is applied in order for insuring the real estate. But the banks, when it comes to the real estate market, but now this real estate market is stagnating. So the banks give out loans on the basis of the liquidation value minus 30%. To make sure that if the loan isn't paid back to the bank, then in that case they have this guarantee that they can get their money back, that the investment the bank made, so to speak, will be returned to it. Yes. I have a question. Now I realize that I have a question. Looking back and thinking back of your answers and what you've mentioned, the values that you calculate on the basis of different methods used by the cadastral authority, the techniques applied by the cadastral authority. And I would like to know, for you, this final handover-takeover document that is issued by a commission established for this purpose regarding real estate, does it have a legal force, or is it just an informative document? What document? The final handover document that is established by a commission that specifically deals with the official taking over of the asset. Does it have a legal force for the calculation of the value of the asset, or is it just a document for information purposes only? In addition to this document on the final receipt of an asset, well, that asset has to be registered with the cadastral authority. If the real estate, if the property is not registered, to me, that's not a document. When the asset as real estate appears in the cadastral records as a construction, accompanied by ownership documents, also recorded with the cadastral authority, that is the basis for the owner to have rights onto that real estate. That is only after it is registered, and that only then the report has legal force for me to perform the assessment, the appraisal. If it's not registered, if in the real estate it does not appear, that asset does not appear, then it cannot be subject to such an appraisal.
Mr. Mikilionis, do you have any questions?
Mr. Mikilionis, do you have any questions?
No, thanks.
Thank you. Now, Mr. Grossu, no more questions from the panel, and we'd like to look at the prosecutor now, whether he has any follow-up questions to ask you. We need you to use the microphone. Thank you, Mr. Gross. Now, speaking of this particular instance, though, in the hearing, I've mentioned that as part of this evaluation, I've mentioned that when my father built the house beginning in 2008 and completed in 2011, if I'm not mistaken, according to the documentation issued by the cadastral authority, I've explained that they've used concrete plates, slabs from a different construction, and some other leftovers. And I think that's something that was also mentioned by the chair of the panel. How much would that impact the market value of such a property? I mean, the roof was new, the plaster was new, the windows were new, the bricks were bought. But speaking of the foundation and speaking of 5 concrete slabs, how much that could have influenced the market value of such a property? I understand the question, but in this case, if the construction materials used for building a house, if that was used before, they cannot be used further on. If it depends if on the stone, there's some stone that could be good for use at any time, even if it was previously. If according to the norms, to the rules, even after an asset is made available for use, well, there are people who examine before an asset is made available for use. There are technical engineers, technical experts who carry out investigations at the site, and they can establish whether this construction was erected in line with the rules or not. If the construction materials would have been worn out, as in a way that you wouldn't have been able to reuse it, then that house or that building wouldn't have been allowed to be moved into or to be used as such. I have another question and a comment, Madam Chair of the panel. You stated that the cadastral value, when it comes to the price established by the appraiser, you've mentioned there's a big, considerable difference, though you didn't say what the difference was. But I would like to mention the 2013 sale and purchase agreement that states explicitly that the value, as per the certificate of the cadastral value, the value is 517,625 lei, about 32,000 euros. So at that time already it was established, as the appraiser stated, the price, the minimal price for taxation purposes, that's 32,000 euros. As for the report issued by Mr. Gross, that was 47,000, so I think it's quite realistic. Well, in fact, I did not mean the 85 or 87,000 that is indicated in the final handover takeover, but I mean, that is the value that I meant, not the one in the cadastral register. But final handover was about 180,000 or 140,000. That is the final handover act. Well, we'll go back to these numbers. We will. It's not a problem now. I mean, it's quite a lot of numbers, so we will need to sort things out. But do you have any questions to Mr. Grossi? Yes, there is one question that I have in mind. Now, Mr. Grossi, you've stated that, or maybe, well, regarding the difference between finding and opinion. Well, the finding, as in this amount was found to be as at that date, or is just an opinion that could be a different one if there was a different expert? Could you provide more clarity regarding it? Is the date, is the amount established as at that date? In the report, we put down the value of the asset as of the date of the transaction. That is my opinion that I will have arrived at through a method I've applied. Out of the two methods, I've applied one. So that is more realistically reflecting the market value compared to the other method. That's what it is. Now, prosecutor, any other questions from you? Any follow-up clarification questions you would like to ask? Then you may do so. I think that was all from me. Thank you, appraiser, for your participation. And the panel has a kind request. If we happen to need some further clarification, if we happen to have some other questions, because we'll be thinking things through by the time we get enough clarity. So hopefully we can count on you and your clarifications through email, and it will not require physical presence. All right, I will gladly answer your queries. Thank you very much, and you are free to leave. Thank you, and have a nice rest of the day.
We are resuming today's hearing of Prosecutor Alexandru Gaina from the Anti-Corruption Prosecutor's Office. And now we are going to discuss about the doubts, Mr. Gaina, that were presented to you in the hearing notice. One or more members of the panel will have questions for you. I would like to remind you the kind request I had from the very beginning, like speak slowly and clearly to ensure an accurate interpretation, that's both for the international member and for the colleagues of the public that is going to watch this hearing, both in Romanian and English. So I would like to remind you that the doubts relate to the inexplicable, well, for the discrepancy between assets, income, and expenses that the Commission found for the years 2013, 15, 17, 2018, and 2023. These are the years that fall within the evaluation period. The amounts are different for all of the years, but all in all, they exceed 1 million lei. That is the amount calculated by the panel. So now we are going to ask questions to see if this amount stays as found by the panel or be decreased or be increased, depending on what you can clarify about the uncertainties or uncertainties that we have. To this end, I'm going to give the floor to Mr. Mantas Mikelionis, who is going to start the questions, and then each of the members has the right to ask you questions as well.
It's your round.
Thank you, Mr. Chair. So, Mr. Gaina, let's move to the question section. According to calculation made by the panel based on the available information, you have a total justified wealth in the amount, as was mentioned, of 1,059,565 lei in the evaluation period starting from 2012 to 2023. Detailed information is included in the hearing notice. The identified and justified wealth is largely due to the fact that your ongoing financial flow includes payments related to the purchase and renovation of the apartment in the area ownership of your father, located in the Chișinău municipality, Rishkana sector, Bunăvestire Street, and to the purchase of 2 vehicles BMW, model year 2013 and 2017, owned officially by your brother. The panel seeks to clarify the information available and provided by you, including your written statements received yesterday, as well as the information specified in the hearing notice. We have grouped the available questions. First of all, we'll ask questions related to the purchase of an apartment located in Chișinău municipality, Rishkana sector, Bunăvestire Street. Another group of questions related to the purchase of 2 BMW cars registered in the name of your brother. And the third group of questions related to imbalance for the years 2013, 15, 17, 18, and 23. So let's move to the first group of questions related to payment for the apartment located in the municipality, Rishkana sector, Bunăvestire Street. According to the information from the real estate register, within period 2014 to 2023, in your father's name, the 2-room apartment was registered with an area of 79 square meters located in Chișinău municipality, Rishkana sector, Bunăvestire Street. On 27 of March 2014, your father concluded the contract for investment in housing construction. According to the contract, your father purchased the apartment for 53,000 euros. Your father paid in 2 installments, 926,565 lei transferred on 27 of March 2014, and 56,990 lei transferred on 31st of December 2014. Is this information correct? And could you confirm this information?
Yes, I confirm. With respect to the payment period by my father.
Thank you. In the first round of questions, you stated that the apartment was intended for you from the very beginning. The apartment was and is used as the main residence of your family, and you cover all expenses related to the payment of utility bills and the maintenance of this apartment. Is this information correct?
Not exactly. I would like to comment here. From the first round, I mentioned the following. This apartment was purchased from money received from selling the house in Jedinets town that belonged to my father in 2013. It was built in the years 2008-2011. It was sold in 2013 at the market price of 43,500 euros. Subsequently, they added a part of the money, as I mentioned in other rounds, from previous savings, because being employed in the law enforcement authorities since 1976 to 2004, being involved in service, having salary, pension, indemnities. I provided plenty of detail in the rounds about the source of the money that was set until the year 2012. To that end, a fiscal declaration was filed and the situation of 1st of January 2012, where he declared available money in the amount of 900,000 lei. That resulted, of course, for the year until 2000, it was hard to provide confirmation documents because many witnesses of that time, unfortunately, have passed away already. And in that period of time, in the 90s, like accounting documents or other documents were not being issued, and everything was mostly cash and not documented. So generally, I meant the sales in the 90s of two vehicles. One of them was Volga Gaz 24, assembled mostly artisanally, so many spare parts were purchased. So many spare parts for it were being bought and then sold a bit later on in the early 2000s. So I mentioned the vehicle Volga Gaz 24 was sold for $3,000, and I mentioned the person, the concrete person, $3,000, and that is, if I'm not mistaken, let me see, 1997, 1998. The parts, the spare parts, there were the dashboard, the spare parts, because that was, as I said, a car that was put together from parts. Many new parts were kept and they were sold to a state enterprise. And I mentioned the company and who the person was. Unfortunately, that person passed away at a price of 15,000 lei. The apartment was sold initially, a 3-room apartment where our family lived, and after we left as students, it was sold. A 3-room apartment was sold, and they bought a 2-room apartment, and the price difference to it, and some indemnities, salaries, and all of that until the year 2000. Not even to mention unofficially, as it was being done in that period of time, all parents were also going to Romania, selling some household devices. So there was both official and informal income until the year 2000. Of course, I can't say the precise date or amount, and I presented up to 200,000 lei they certainly had at home after the year 2000. He was also involved in employed officially. Since 2004 he was retired, but he was also employed and provided security services for the company where he was administrator and founder. Again, in the period 2004 to 2011, I mentioned circumstances that were confirmed by declarations on selling in the season, buying apples, selling them in the Russian Federation. There's a witness who confirmed from 2004 to 2007 they were loading apples from orchards. They were transporting them to the Russian Federation. My father was also taking part in that. He was buying on his account 1 ton, 2 tons of apple, loading it together with people who were exporting those apple, and he was getting, for every round per year, he was getting up to $2,000. This lasted between 2004 and 2006-07, so that is 6,000 more. All of that is confirmed by the declarations of a person who had those cars, vehicles, who was dealing in exports of apples. Also, there are statements of a witness who confirmed that in all these years, between 2004 and 2011, my father was growing animals, 2, 3 pigs, some cow, and at the end of the year, when they reached a certain level of maturity, they were sold before holidays, and some money was made out of that. I provided the calculations in the question round. A larger amount, substantive amount that I invoked in the doubts in my explanations is the sale contract for the house in the year 2004. According to the contract of 5 of February 2004, number 584, of the house from Jedinets, 10 Trandafirelor Street. According to the contract value, it was 81,000, but it was sold for 25,000 euros actually at that period of time. To confirm this statement, we have statements of the person who found those buyers, who supported the negotiation, because the people who bought the vehicle are friends of the neighbor, because my father built the first house in the years, started to build it in the 90s, but sold it in 2004. And to support the actual price for the transaction of 2013, I contracted the services of an independent appraiser who was heard earlier. We presented the price and the value. I think I said by the appraiser was not 25 but 22 or 23,000 euros. That is the value established by him, but actually it was 25. But he said there could be an error of give or take 10%. So all the arguments and evidence that I provide is that factually it was possible for him to have had the amount of 900,000 lei that was declared at the beginning of 2012 to the cadastral body. Also, in 2006, he received the preferential credit as a participant in the Transnistrian War. He received 80,000, out of which he had to reimburse 40,000, and 40,000 stayed as income. A sale of a garage, we have only declaration, unfortunately, no documents, but it was also 25,000 lei. We have declarations for the person who bought it, but documents, no, I believe that maybe at that time there were not even documents, maybe it wasn't registered with the cadastral body. My father still, to this day, has another garage in Jedinets, which is not registered either, but it was built in the 90s. Arguments. These were arguments for the amount of 900,000 lei that was declared to the tax authority as available cash. Grosso modo, the amount for which the apartment in Brășcani sector Bunăvestire, apartment 27 in 2014, that money comes from selling the house in Episcop Dormidont Street number 18 at a price, market price of 43,500 euros. In the contract, The transaction value is only 280,000 lei, according to the abstracts from the real estate register issued by the cadastral authority. The value is 517,625 lei, that is 32,490 euros, but actually it was a high price at the time, 40,500 euros. That confirms the amount, the circumstances that the transaction took place at a market price. On the date of the transaction, 5th of July 2013, the seller, or the buyer, sorry, with his son being present at the bank, the money was checked by employees and they were put on the account of my brother as a deposit on the same date. It was confirmed through a payment receipt, cash receipt order, beneficiary Gaina Alexandru, total amount 43,500, statement of account on the same day, 05/07/2013, balance 43,500. The declarations of buyer's son who was present there when the money was transmitted in the bank. I did not participate in negotiation. I was not part of the transaction. I only was verbally informed by my father that the house was sold for this amount. And as in the first round, I knew about 45,000 euros. Details about how much was written in the contract, or who was there, who are the buyers, how did the transaction take place, I did not know until the first round of questions. And it was exactly in the first round of questions I asked my father what was the value, what's the source of money. I knew that the money was in his account because this apartment in the Rishkan sector was purchased in 2014. After some time, by bank transfer, this money was transferred into the account of the economic operator. As you mentioned, it was done in 2 installments. According to the sell and purchase contract. Regarding the fact that it was meant for me initially, it was my father's purpose to improve the living conditions of our family. At that time, it was my father, myself, and my brother. And once this apartment was purchased, my brother was related to the two of that. At that time, he was, it was for me and my brother, but my brother left, and I stayed there. And as I mentioned in the question rounds, initially when he came back to the country, he lived in that apartment for a while. The essence, in terms of, money laundering and NIA legislation, the origin of funds, legality of funds. In this case, we talk about beneficial owner. In this case, both de jure and de facto, my father is the owner. To this day, I don't have a ownership translation document. By this time, I have 2 minor children. There is my brother and myself. My father will be the one who will decide on the fate of this apartment. Maybe he will leave his inheritance to my children, or maybe to my brother, and then myself and my family will have to live. So he is the owner, de jure and de facto. Yes, I did not hide that I was living there. I declared from the very beginning in 2015 to the National Integrity Authority. And in all declarations, the annual declarations filed to NIA, I declared that I was living there. Then why different dates about where I was living? Probably I tried, and I explained it in the question round. When you fill out the declaration of assets and interests filed to NIA, when you check or when you automatically open, it shows you the name, if I'm not mistaken, and your domicile, registered domicile. My registered domicile is in the apartment on Albishara Street. That's why every time I had to intervene and correct the address. On the other page, it was I presume it was going back to that initial address, but I never denied it. And there are some years when it's not declared as domicile in the NIA declaration. For instance, 2015, 2016 is there, 17 and 18 is not there, 19, 20 it is there. So this shows my intent. I have never tried to hide this from the very beginning. The essence is establishing the legal provenience, legal origin of the money, and the de jure and de facto owner. I tried from all the documents and circumstances to prove that the money is coming specifically from that sale of the house in 2013, the 43,500 for that. And in order to establish the market price and to confirm that it was a market price, I contracted services of an independent appraiser, and well, that was confirmed even from the practice of the Commission. Every time when in the transaction the cadastral value is used, or you always insist on establishing the market value. And in this case, the value of the transaction is twice smaller than the cadastral value, which is nonsense. I understand my father explained that at that time, this is what they used to be in order to avoid paying taxes. I explained it. I wasn't there. I don't know what data they wrote in the contract, and this is what he explained. But it's the market value that matters, and according to the established practice and realities of Moldova, the cadastral value is 2-3 times smaller than the market value, and this was confirmed by the appraiser as well. This is a reference value for taxation purposes. The market value is higher, and it corresponds to the amount for which it was sold, 43,500, which was confirmed by the declaration of a buyer's son who is currently living there with his family. According to the documentation that was provided to the appraiser, because I asked them only in the last stage when I believed it was necessary to find additional evidence to confirm the market price. And if I'm not mistaken, in April, I requested that cadastral file and all documents from the cadastral body with respect to that house. And the pictures, it was me who asked for them from the buyer's son, who is still living there, because my father certainly did not have a telephone with photos, and neither did I. And I asked him if he kept them. He was a person interested in that. And they kept photos of that real estate. And I provided, at the request of the expert, I provided those photographs and the entire cadastral file with the entire set of documentation from the cadastral authority. That is with respect to the actual price, market price, and from their own savings he added the difference for the second installment that we mentioned. This is the explanation and the arguments for the origin of funds from which that apartment was purchased in the year 2014 in Râșcani sector, Bunăvestire Street, 15-2, apartment 27. And if I may, to continue this idea, with respect to the renovation of the apartment, when it was purchased, I think the handover was 2015. Between 2015 to 2017, the apartment was being renovated. In the question round, I explained that it was also from the savings of my father, The renovation was done 8,000 euros, and I contributed with 3,500. That is year 2015 to 2017. That is partially used furniture and household appliances. A part we borrowed from the old apartment, and a part was purchased new. And as I said, when my father came back in 2018, 2019, he lived in that apartment for a while, and then everyone with his private life. He was living both in the apartment on Albishara Street. We also have a house left from our grandparents. We use it as a summer house. So that's it. 2018, 2019, he was in Moldova. In 2020, he had to travel. He's a Canadian citizen. In 2020, he moved to Canada for personal reasons, private reasons. And when the COVID pandemic hit, he had to stay there for 2 or 3 years before he had the possibility to come back in Moldova. In 2023, he came back to Moldova. In the meanwhile, I started a family, children, wife. We are living in that apartment. But to this day, I have no document that would be translating the ownership to me. Thank you.
Thank you, Mr. Gaina, for your clarification. I would like to return to the apartment in Chișinău municipality, Bunăvestire Street. So, as you said, this apartment was bought by your father in 2014. And I would like to repeat my question. So in the first round of questions, you stated that this apartment was intended for you from the beginning of the purchase of this apartment. And this apartment was and is used as the main residence of your family. And you also stated that from the beginning you cover all expenses related to payment utility bills of this apartment, also covered the maintenance of this apartment. This information is correct. Could you confirm that?
As I said, I only have a comment. From the first round, I said it was meant for improving the living conditions of our family. Our family at that time was myself, my brother, and my father. The apartment where my father and I lived was a one-room apartment. So after the house was sold, the house in Yedinets was sold in Yedinets for 43,500. My father decided that it is possible to purchase another apartment for me and my brother. That's what he said. Because my brother at that time was in Canada, and at that time it was me living there, but it was meant from the beginning for the family, and that was my brother and I. That is what I said in the first round. But my brother was in Canada, that's why I moved in there, and my father was coming every once in a while to Chișinău, and then he had that money. I mean, if he didn't sell the house, didn't have that amount of money of 43,500, he wouldn't be able to buy the apartment. Speaking of utilities, of course, since I was the one living there, I was paying for utilities. I did not hide it. Starting in 2015, I was declaring it to the National Integrity Authority.
But that doesn't mean that I am de facto the owner of that apartment.
Thank you. So another question is related to the real estate complex in Edirne district, Edirne municipality. As it was already mentioned by you, this real estate complex was sold in 2013 by your father. The contractual price was 280 lei, but the real price, as you already mentioned, was 43,000, 5,000 euros. So could you once again to explain the discrepancy between the actual paid price and the contractual price, the reason of the differences in prices?
As I've mentioned, and you two have established that in the second round of questions, if I'm not mistaken, well, let me start with the beginning. There was a question in the round of questions. What is the value? What is the origin of the money paid to buy the apartment that you've made reference to on the Bunavestire Street, Chisinau municipality? And I stated that the money came out of...
So sorry, I would like to interrupt. The question is not about source of money, but I asked you about the discrepancy between the contractual price and real price of the sale purchase real estate in Edinet municipality in 2013. The discrepancy in prices. Contractual price was established 280,000 lei, and the real sale price was 43,500 euros. So how could you explain the difference in prices?
Understood, Irmantas. I was just going way back to get to the answer that I was going to provide to this question. So according to the explanation of my father, as stated, I did not participate. I am not aware of what that contract stated. It's in the second round that I found out what it said. When the panel asked about the explanation behind this difference that you two have just mentioned. Initially, I thought there was an error, because out of my experience and practice, I knew that below the cadastral value, a transaction cannot take place at a value lower than the cadastral one. So out of the text that I saw, I've seen the contract that it said that according to the cadastral value, that the price of the real estate was 517,625 lei, and the transaction of the sale and purchase, the transaction that value was 280,000 lei. So initially, I thought that was a typo, like an inadvertent error, because at that time in Moldova's practice, they would, all of the transactions would happen at the normative price, and that was because to avoid paying taxes or not to pay taxes whatsoever. So that used to be a practice that was, not established, but very common in Moldova back in 2013. So I've explained that I believe that the cadastral value is perhaps 280,000, but the value of the transaction was 517,000. But then I learned that that was possible. The cadastral value was 32,000. So, as I've explained, what is the economic reasoning, the economic rationale behind it to sell an asset, the cadastral value of which is twice bigger than the value of the transaction? So it does not make sense. All the more so since, according to the established practice and even out of the experience of the Commission, I've noticed that every time that the transaction was established at the cadastral value, as was usually the case for the contract, the market value would be 2 or 3 times bigger. So in this case, the same has occurred. They've established the smaller amount, as Father said, to not pay taxes, but the market value was 2-3 times the cadastral value. So that was the reality at that time. Now, was that good or bad? Well, I did not know about it. I was not consulted upon it. I had no idea about those circumstances around those transactions. And in a discussion, I was told that the house was sold, and I didn't even know who the house was sold to. I didn't know who was that person, who the son. I didn't know the seller. I didn't know the son of the buyer. I didn't know who bought it and who was the son of the person who bought it. Back then, I was not even a prosecutor, by the way. I was working as an officer in the National Anti-Corruption Center. I was at work and I was not participating in transactions like that. I was not aware of it. That was his personal affair. I knew that the house was sold, but I think he did tell me the amount, 45,000 or whatever. I think he did tell me, but at the end of the day, I mean, the discussions were around 50, negotiations took down to, was supposed to take it down to about 45,000, and then that's how they reached that amount, the 43,500, and that's why he wouldn't remember. When I asked him verbally what was the amount, he said 45,000 euros, and that's what I put down in the first round. Thank you.
Thank you.
I hope I was clear enough, and I'm ready to provide further explanations if required.
Thank you. So in 2014, 9 months after the sale transaction of real estate complex in the Net municipality, your father submitted his income tax declaration to the fiscal authorities for the year 2013. In that declaration, your father reported the capital gain arising from the sale of the property on the basis of taxable amount of 280,000 lei, corresponding exactly to the sale price stated in the sale purchase contract. Could you explain that the tax return did not indicate the income actually received from the sold property, but the lower contract price?
I think that the legal basis was specifically the contract for paying the taxes. And given that the contract says 280,000, the tax inspectors collected the tax on the basis of the contract. So at that time, I don't know the details to be able to say, well, that I've acquired that income of 43,500 euros. But the purpose, as he said, was to put us in the contract as small an amount as possible to pay less taxes. And the legal basis for the taxes was the contract, and the contract was presented, and it's on the basis of that contract presented is that the tax inspector calculated the amount of the tax to be paid. But Irmantas, the market value cannot be twice smaller than the cadastral value. I mean, that wouldn't make sense. And as the expert stated, that was a house that was newly built. It couldn't have costed half the amount. I mean, the cadastral value is just for taxation purposes. It's not the market value. Even a mere calculation, mathematical calculation, even not an expert myself, the size of that house was 250 square meters, and the value in the contract 280,000. If we divide per square meter then it would be about 1,000 lei, and that would be 50 euros. It's impossible for 1 square meter to be 50 euros for a house completed to an extent of about 80%.
Thank you. So in December 2012, your father submitted to tax authorities the declaration of the individual regarding the availability of funds as of 1st January 2012, in which your father declared that he held 900,000 lei in cash as for 1st January 2012. You already provided some information regarding your father's income before 2012. Maybe you can explain another additional sources from which your father has accumulated the amount by 2012.
In broad lines, I remember having spoken about all of the sources, but let me have another look at it. Additionally, as regards my position regarding the doubts identified, I've provided over there in my response the table of income and expenses for 2011 for the father of the subject, Gaina. Calculations were made regarding the sale, among other things, of, for instance, livestock. I made calculations from 2004 through 2011. There was confirmations provided by statements of people in the rural area over there where my father was raising livestock. That's about 3 or 4 animals a year. They would be of a weight, of a proper weight. Once they would reach proper weight, they would be sold at the Jedinets market. There is a confirmation from one of the administrators, and there were also witnesses, from witnesses as well, those who were also engaging with raising the livestock. From 2004 onwards to 2011, there are calculations regarding the livestock kilograms, more or less market price. I will not go into the details of that. That is already presented, and I think there was beef, pork, price per kilogram of these, and there would be about 16,000 lei a year on average. From 2004 to 2011, 128,000 lei in total. Next, out of, well, considering what I've also stated regarding the sale of apples, so sold to the Russian Federation and Belarus. That is 2000-2005, that period when the owners of trucks would buy apples from households, from orchards. They would load that onto the trucks and would take that away. Or the buyers would come over to Moldova from the Russian Federation, from Belarus, and they would buy the produce. In this case, we're speaking of a witness that confirms that having a personal truck, they would engage in the export of apples to the Russian Federation on their own. It was not a company as an enterprise whatsoever, but as a natural person, an individual. They would take that to the market and sell it at wholesale markets in Russia or Belarus, according to the statements that were annexed. Out of the entire quantity, 10 tons, 2 tons were of my father's. He would buy when the season was proper for that. After the sale, the truck with all of the produce, for instance, that would be about $7,000 a year out of the statements of that person, and 2,000 would belong to my father. That was 2004 through 2006. According to the exchange rate at the time, 25,000 lei. That is 76,000 lei if we add. So back then, 2005, 2011, my father would tell me about having 50 families of bees. And the yield was about, I mean, now I got into the details, but I am not a specialist in honey, but I mean, there are a lot of calculations. 100 kilograms of honey, 50 of that would be for to maintain the bees, and 50 would be sold, 20,000 lei a year. So 5, 06, 07 until 2010, that's 140,000 lei added. So next is for 2004, 2011, the pensions and allowances, 375,000 lei. And moving on to the sale of the house that I've been speaking of, 2004, that is the market value, 383,000 lei. And then some other deposits that he had, and so on and so forth, not to mention the situation until 2000. So these are the calculations regarding, well, the sources that I've managed to clarify. Until 2000, there was that Volga Gaz 24 that was sold for 3,000. And there were parts that were sold for, and then a garage, 25,000, and that's 2000, 2011. But until 2000, I mentioned what was before that. He was hired at work, and he was using the company car, so to speak. And back in 1998, he sold his own car. As for the difference of price, well, in it was 3 rooms, and then he bought one with 2 rooms, 2 bedrooms. So through his lifetime, he's been gathering funds. But the biggest one was the 25,000 for the house that was sold in 2004. Additionally, some of the other activities that he would engage in where he had the income that I've mentioned. So maybe I cannot prove with certainty each and every leu that was collected, but it's realistic for him to have had that amount of money. There were facts that supported it. It's not an arbitrary statement, all the more so since to the tax authorities, the documents were submitted and the tax authorities could have checked it, and it's still in force as of today, and it's realistic. For a lifetime, he's been working with, well, at work, he was at work, he had pension, he had activities, he was administrator of 2 companies. So these amounts are not exaggerated. Thank you.
Thank you. Based on gathered information, as well as the official documents provided by you during the rounds of written questions, the panel established and included in the hearing notice that your father received total income of 1,507,500 lei during the period from 2000 by 2011. As I said, the detailed calculations were presented in the hearing notice. And do you agree with this panel calculation? If not, could you provide your calculation?
Well, I believe so. I provided my calculations, the estimated ones, more or less, in my response. To the doubts raised by the Commission. So my position as the subject, with regards to the doubts of the Commission, of the panel, I've already provided that, more or less, according to my calculations. The amounts accumulated from 2000 to 2011 amount to about 1,016,000, and I would like to remind you, prosecutor, that something that we've mentioned at the beginning of the hearing, that what you submitted, your position to the hearing notice, and your explanations, and the explanations provided by the appraiser, you provided that in the second half of the day. So I'd like to remind you that the panel did not have sufficient time to examine that and check that against the doubts that we've identified. And that is why we've asked you that anything that you'd like to mention, to take from that written statement of yours, that you would like to state out loud during the hearing, that you may do so. And after the hearing, we will look again at all of the explanations provided by you in writing. Thank you. So I will just reiterate that according to my calculations, the amount is from 2000 to 2011, 1,016,000, and until 2000, there were 250,000 lei set aside. So more or less, I think it amounts to the calculations that the panel itself has made.
Thank you. You already provided some information regarding your father's income before 2000. Could you tell us, did your father have any savings in 2000?
Yes, as I've just mentioned, turns out that until the year 2000, as I stated, about 250,000 lei, more or less. Well, to say specifically, I mean, that was 25 years ago, so to ask how much exactly you had in 2000, I just wanted to show that until 2000 there were assets that were sold, such as cars, apartment. More or less, in 2000, he could have had about 200,000, 250,000 lei as savings set aside. It's complicated to say now with utmost precision how much money he had in savings in 2000. I mean, that was 25 years ago. And esteemed member of the Commission, I would like to just confirm the fact that he was working, he was employed, he had a source of income, he had a pension, and in addition to that, he had assets, movable and immovable property. So it was realistic for him to have amassed some savings throughout his lifetime, including as at 2000 in that year.
Thank you. You already explained to the panel that in 2013, 33,500 euros were deposited in your father's bank account. Could you provide more detailed information on how this money were deposited in bank, who did it, and who participated in this process?
Thank you for the question. As I mentioned, out of the statements of my father, he stated that at the time of the transaction, at the time that the transaction was concluded at the notary, the money was not transferred. For him, the amount was big, so he insisted that the money be handed over at the bank and that their authenticity be checked to make sure that the bills were genuine. So the son of the buyer he came by car. After the transaction was concluded, they went to the bank that same day. Now, at the bank, the money was handed over. The money was checked by the operators at the bank. They were converted, exchanged into Moldovan lei, and deposited to the account on the same date with the transaction, the 5th of July, 2013. So, out of what he said, it was himself, my mother, the buyer, and the son that currently is living there with his family. And by the way, these statements were also confirmed by the son of the buyer at the request, my request, and well, I requested for those statements, I asked for them, and then I saw that the commission too so asked for it. So the same statements were confirmed that the money was transferred to the bank and the amount was 43,500. As I explained, I didn't know who that was, I don't know. And having asked my father to find the buyers, he found them to confirm the amount related to the transaction. The son or the mother or the lady, when I've asked him for statements, that was a phone conversation. I haven't seen them in person. And I did not participate in that. And I've seen out of the evaluation file, the notary confirmed that I did not participate. I wasn't there when the transaction occurred. And as I said, Mr. Irmantas, I was not an employee of the prosecution service back then. I mean, essentially it doesn't change it still, but I was an officer and I was at work. And I couldn't have. And by the way, with regards to the integrity, professional integrity and ethics, I submitted a certificate released by the National Anti-Corruption Center confirming that throughout my entire service since 2003 through 2014 July, for as long as I've worked in the center, I've only been provided incentives and I have never been subject to any penalty or sanction whatsoever. So this was also my way to address the matter of issues or doubts with regards to my professional ethics and my professional integrity. Just so you know that, so just so it's clear, and so my reputation, so it's clear what my reputation was. And to address the matter, the question marks about this money, I wasn't there, I was at work, I did not participate, did not engage with this, and I had and I continue to have a good reputation. Thank you.
Thank you for your answer. What expenses have you incurred for the renovation, interior finishing, furnishing, and equipping the apartment with household appliance located in Chișinău municipality, Rishkane sector, Bunăvestia Street, from the date of its purchase in 2014 until 2023?
As mentioned in all of the rounds of questions, for the renovation of this apartment, my father participated. His participation was of about 8,000 euros. I was not able to provide beyond any doubt with certainty how much money a month would be given. That was for the entire period when renovations were made, 2015 through 2017. As for my role and contribution was about 3,500. That's about 2016. Yes, I think that was that 2016, 2017. I would purchase some furniture, some household appliances. That was my contribution. So my father, as I said, my father had funds available, and he gave me as much as he thought was due or possible, and the rest, I took care of the rest. And the value was about 3,500 euros, more or less realistic for renovations in the apartment, all the more so since it was the so-called white variant of the apartment. So those were the costs for renovation works.
Thank you for your questions regarding this issue. Mr. Chair, I don't have more questions on that. Maybe other panel members have questions.
Domnul Micheleanu, am să intervin și eu cu
I do indeed have a couple of follow-up questions regarding this matter, and then afterwards we can move on to other questions. I believe now I would like us to have more clarity about certain matters, since we are speaking about the apartment that was mentioned on Bună Vestire Street, purchased by your father. In the rounds of questions and answers, you've stated, and you've also said it during today's hearing, that it was meant for the children, that at that time you thought it was for you, your brother, the father hadn't decided who that was going to be for ultimately, which one of you or your brother that is. But can you tell us, well, your father has periodically lived, as you yourself stated, has lived in that apartment? No, I said in the very beginning he didn't. His residence, according to the information available to the panel, and having looked at the register of citizens, we've seen that periodically, in certain years, for shorter or longer periods of time, there was this duration of the residence that was in the Bună Vestire apartment registered, and on Independența Street in Edinets as well. So, can you tell us what need was there? I could also tell us specifically what time that was, that period that was. Well, that is not required, Madam Chair of the panel. To me, this is not of great relevance for proof of residence permit. Let me tell you why. I would like to say that it's not that it was meant to me or my brother. It was meant to improve the living conditions of the family. For as long as the brother isn't here, I mean, you can stay there. That's what the father said. It was meant for me and my brother, but I was there because my brother thought it was away. It was not that specifically I was supposed to be there. I mean, my brother with his family could come over and move to that apartment, and then I would have to, if I had to move over to a bigger one because my family is bigger, or some part of the money would be paid, or the other way around. I mean, we would decide that as a family, but the father is the owner. As regards, though, this registered domicile, this residence registration, the explanation is ordinary. You might have seen that the period coincided with the election period. So when he was in Chișinău and he needed to vote, he would change his residence registration to be able to vote where it was easier for him, where it was closer for him to cast his vote. So that's what mattered. It was either related to paying the taxes for real estate or something related to allowances. He was retired and put some facilities whatsoever for having changed the domicile registration, because you would say that he would sometimes live in Criuleni district, in that villa. I mean, that has begun back in about 2018 or 19, but that's isn't influenced or based. Essentially, either way, this residence registration would change depending on the needs. It could be related to voting, so that he wouldn't have to go to Edinets to cast his vote for the different local presidential parliamentary elections. And more or less, if you pay attention to that, there might be some overlapping periods with elections, I mean, and for receiving some allowances whatsoever. But he's never lived there. That is the explanation. So, in fact, he's never lived. And your brother has also not lived there. My brother lived with me in that apartment for a while. When in 2018, 20-something, when he was back from Canada. For how long? A year or two, a few months, or how many months a year? I mean, there were different periods of time, different lengths, depending on his lifestyle, his private life. When he needed to, he would go to that apartment or stay with me, and it was not very strict as in this and that period of time. Understood. So both you and, in fact, de jure, your residence registration is on Albișoara Street, but you actually live in that apartment with all of the other statements that you stated. I mean, yes, I pay utilities. Still, why did you not change your residence registration, your domicile, to that apartment? Was it something that your father prohibited you from doing, because then as an owner he was supposed to grant you that or allow that or give his approval. I don't know. I mean, there was no need. I never wondered about it, never asked myself about it. It's not about the registration of residence. It's about ownership, and I don't have ownership. Well, it depends on how we look at things.
That is an issue, since I'm not doing it. But who is actually living in the apartment on Abdeșara Street and for the entire duration of time since you left? Do you rent it out? No. Or is it just a reserve? My brother. So, when my father comes to Chișinău, he stays there. When my brother comes for some period of time, he comes, he leaves. So it's my father, my brother. With respect to the investment made into the apartment, as your father said that it is for some of the children, did you? Well, you had a contribution to the extent possible, 3,000 or 3,500 euros. Did your brother invest anything into that apartment, into the renovation? Since you said that no, he wasn't in the country back then. He wasn't in the country. So at no time he contributed to the improvement with some amounts. It wasn't necessary, since my father had that money. And since I stay in Moldova, I live there, I am incurring. If he decides to stay, he could, I'd give him part of money, or they could reimburse, or, well, we will decide. Going back to the sources of income that your father was receiving in the period before the evaluation period, before 2012, he was employed in the law enforcement authorities, as you have answered, and according to the information that we have available, but you also provided declarations of third parties who stated that your father had certain income from other activities. At certain stages, while your father was still employed at law enforcement, that is overlapping with the periods when he had other activities on it. No, it was until 2004. He retired in 2004. So after that, he had time to do some extra activities. So other activities followed after 2004. Until 2004, your father also had some real estate in ownership. Built a house, sold it in 2004. We are trying a recap, not precisely mentioning all of the things. This property, was it all obtained by your father by own financial resources, or some of them obtained by inheritance or donation? If you know that, of course. You mentioned that he had a garage, now he has another garage, which is not registered with the cadastral office. The house, Madam Chairperson, as I mentioned, a capital. There was some capital from selling the house, parents' house, which was quite renovated, after the grandma died. Do you mean grandmother's or parents' house? I'm talking about grandparents' house. That is the source of another amount, and that is year 1986, 1989, and then the house was sold for 10,000 rubles, as we said. Having two sisters, he was the youngest. He received the largest share. As the relatives are saying, 1,000 or 2,000 were given to the sisters, and the largest share stayed with him. And having that money, he paid for a lot of construction materials. Back then, there was a lot of stone quarries in Yadinets, and as every Moldovan, he had the purpose to build a house, and so on. So, another vase car, second-hand. He sold it and purchased from 01 to 06, and so on. There were payments for many construction materials, quarries, and so on. queries. And with the independence and all the restructuring, many of them failed and so on. And after the 90s, what was left reformed? Part of the materials he managed to receive. So that's why in the 1992, 93, they built this summer house, and then it was dismantled, and the house was built from that materials, then traveling to Romania. And as it was happening in Moldova, going there, buying household goods here, selling them over there, and so on. That was all done from own resources. Do you mean own resources? That no other donation, own resources. I'm trying to explain, give or take, what I mean. The financial resources received from the grandparents, and divided among children, your father and his sisters, a part of it. Well, it was a capital. Let's admit, we are from the same generation, and we recall the 90s very well, what the situation was and so on. Few of the households from there the ones who managed to gather some capital, they were left bankrupt overnight. And I wonder, where were your parents when the border with Romania opened and the significant share of Moldovans had some, what we say, commercial activities to earn some additional income? They were using financial income from salaries. And as your father was employed in law enforcement, he didn't quite have other possibilities. Back then, certainly no. That's what I'm saying. Or were there things offered to you by your grandparents, some additional resources besides salary? That's what I mean. For that commercial activity. No, Chairperson, no. It wasn't commerce. Well, I'm speaking commerce to meet the needs of the family, to make the ends meet. No, he was not loading trucks, you know. Money received from selling that house, of which he received the largest share. My mother was working, she was an accountant, working for the private sector her entire life. Well, we didn't have a big wealth, but it was that house, and in 2004, it was still incomplete, it wasn't fully finished. And it was more simple with materials, because all the materials was already paid for, because some companies resumed their activity and they fulfilled their duties towards probably your parents were lucky to be able to get. Well, I don't know. It depends on interpersonal relationships. Okay, it's easier in the countryside. Few more questions about your father's activity. From the moment he retired, he started to work in another area, except for law enforcement. He worked in the private sector. You said he was a founder and administrator of 2 companies. I'm interested whether he worked at the same time in several positions. If so, which positions, and the financial resources that he received, both as salary, as an administrator, and other income, dividends, as a founder. No, it wasn't a big activity. All data was provided, there were salaries and they were not large, but it was a source of income, plus pension, plus the indemnity, and plus something, the extra things from the past. Next question. You have graduated from a faculty of law. Did you study on a scholarship or tuition fee? Scholarship. And your brother and your master's degree? Scholarship. Only faculty, only bachelor's. Tuition fee or scholarship? I think he was on scholarship as well. I don't remember him being paying tuition fee. So during your student years, you were already living in the apartment on Albișoara Street with your family members. Going back to real estate in Iedniț, that house that wasn't finished in the contract, we have around 380,000 lei with all of the comments that you made, and the cadastral value that was over 500,000, 518,000. And your father provided this contract for taxation purposes. That's what he deemed necessary to declare to the state tax service. I wonder, do you have a document, final handover? I'm not talking about cadastral value, but because in the materials you submitted, that is about the amount 87,000, if I remember correctly, 80-something, lei? I apologize, I think it's 180. Maybe I did not see digit one. Well, give or take. Well, except for that amount. In order to obtain the cadastral value, that property should have been appraised. The certificate that your father should have had should be requested in order to conclude the transaction. That's the rule for selling real estate, and it has been like this forever. Do you know if there was such an appraisal of the property because this is mentioned in the sale and purchase contract that the cadastral value is that much. But I wonder, do you know any details about obtaining that certificate? Because later on in the contract was a comment, and in the contract the notary is always writing what the parties are asking for. The notary is not writing what they want. Even if it's a standardized type of contract, they mention all the details needed to the parts. We are lawyers, we understand how the system works. So back to that. Do you know anything about the certificate for a cadastral value of 500 something? I believe there should have been some standard procedure, an abstract request towards the cadastral authority, you pay the fee and they issue a certificate, and based on that you can conclude the transaction. Yes, but the final receipt for the construction is from 2011, but the real estate was sold in 2013, so it couldn't have been, well, the certificate, the amount mentioned. Chairperson, the certificate, the cadastral certificate that shows the cadastral value has a validity term of at most 3 months, at least that was the rule back then. I think there's some confusion here. The final acceptance is done by specialists on site and they see the price in their opinion. The abstract is a different document. The abstract regarding the cadastral value, that is another, probably other rules are applied. The final acceptance was in 2011, but the certificate was issued in 2013 for the transaction. That's what I was saying. Do you know anything? Because the cadastral engineer couldn't come and appraise the good in the absence, not the cadastral, the final reception, that's an employee of a mayoralty. That's, in my opinion, this is a document that, in a way, sees the construction, but for taxation purposes, there's another document issued by the cadastral authority. In my opinion, these are two different documents. At the notary, your father should have provided a certificate from a cadastre, an abstract from the register of real estate regarding the value of a real estate for an amount of over 500,000. Exactly, Chairperson. That certificate was submitted because without it, the transaction couldn't have been registered. That's what I'm asking. Do you know anything about the evaluation, the appraisal of the property, and how the certificate was obtained by your family? The appraisal, the cadastral value is established by the cadastral authority by the respective subdivision of it automatically, or maybe it is generated in the software. When you are asking, again, from my practice, not when you're asking for issuance of a certificate on cadastral value, someone starts to calculate your cadastral value. Because if we open the personal file in the cadastre, this is already there. The program is generating, I don't know who, but data is already there. It's not done on demand. It's not calculated when someone asks for a cadastral certificate. That's why, Chairperson, as I mentioned, I did not know any circumstance. We do not. I just want to say that I didn't even know the date of the transaction. I did not know well, they just told me the house was sold for the price. Maybe told me on that day or the second day going to the notary. But details about price and payments, I started to find out details during the second round of questions from the commission. You also mentioned that the amount paid 43,000 or more than 500 for the sale of the property. Do you mean the purchase in 2013, when it was sold, the incomplete house, 43,500. Actual, I mentioned 45 the first time because I did not know. You mentioned that your father went directly with the buyer and the son of the buyer to the bank in order to check the banknotes and to put them into an account. Do you know if the bank asked for documents to confirm the origin of money? I presume so. I don't know. I am not sure the rules were as strict as now. If they wouldn't have accepted it otherwise, you know. This is year 2013, and we had a law passed in 2007, I think, or even 2006, about money laundering, as far as I remember. That was just a clarification question. I can't say, I don't know. I presume that if not, the money wouldn't be in the account. So the money was converted to lei and set in an account in lei. I understand, because what he explained, he had other deposits, or he had other money there. That's why he went to that bank where he already had some money. Thank you, I apologize for clarification purposes, because we'll come to that question. The amount deposited by your father together with the buyer of a real estate was the entire amount, because as you know, some advanced payment. It was the entire amount, 43. Because and it was deposited on your father's name or someone else? Your father's. Okay, and last question. When it was taken out, that money wasn't withdrawn, it was transferred after 1 year in 2014, when he decided to purchase the apartment. So they were wired from the account to the legal entity. Yes, the legal entity who sold you the apartment. Thank you, I have no more questions. So the money wasn't withdrawn. The causal effect, you know, if the house wasn't sold, they wouldn't be able to buy the apartment. Still, in the question round, you mentioned that this price of price for the house was mistakenly written in the contract, and I'm quoting what you said in one of the question rounds. But the difference for us casts doubt always when you have inconsistencies, either when the contractual price equals the cadastral value and we understand the reality and what are the market prices, or in situation where the contract price is smaller than the cadastral value. That's why all of these clarification questions are rising about this real estate. Why do you believe that this was an error, and why didn't they include the actual value of the estate, 43,500, especially since your father reported the income from the contract. He reported the income of 280,000 lei. That's why they probably did that, not to pay tax. Because if you had to pay from 711,000 or from 280,000, there's a big difference. With respect to your comment, if I believe it's an error, I express my presumption that it was an error in respect in respect to the comment that the cadastral value was higher than the value of the transaction, 280,000. In round 2, I said, I did not see the contract. Why didn't I ask any documents from my father? I asked him, how much did you sell it for? 45,000. I am sure that the entire house was 45,000, and then he bought the apartment. It was going through the bank. I did not even think that there could be discrepancy in the data. That's why in round 2, no, I did not see the contract, and if I'm not mistaken, it was the month of, I don't know when it was. He was in Chisinau because he had several health issues, and he was in Chisinau. I didn't have access to documentation, and I didn't even ask them because I didn't see a problem. I knew that the house was sold and the apartment was purchased. But then in round 2, when I received the question, I saw the text, and it was written according to contract of 2013, the cadastral value 516,000, sale value 280,000. From my practice, I believe that from a legal point of view, the notary couldn't have happened. A transaction couldn't be lower than the cadastral. And that's why I believed that probably there was a mix-up, and it was the other way around, cadastral value 280, and from the answer of the notary, I understood that no matter what the cadastral value is, the parties can mention the value of 1 leu. Of course, the parties can agree, and they can establish a high or low price, but we understand the realities, because no one is selling real estate for free. Chairperson, I believe, from my experience, I hope it couldn't be lower. If you have a cadastral value for taxation purposes, it's not allowed to sell under that price. That's why I thought, I didn't even know that it was possible. That's why I was thinking that maybe it should be reversed, the value should be reversed, so 280 as cadastral value and sale value 516. So probably you were not very explicit when you answered. That's why I meant. But the price, 43, if we report it to the square meters prices at that time, it more or less coincides with the actual value, if I may. At that time, and that's 2014 when the apartment in Chisinau was purchased. Let's divide 53,000 euros to 80 square meters, give or take. Around 700 euros per square meters. That's white walls version. Let's say gray walls in Chisinau was 400 euros. So gray walls version under 200. That's 200 euros coincides with that amount. That's the actual value. I understand. Prosecutor, I want you to understand correctly. We don't accuse you of anything. I'm trying to explain. I try to bring up arguments that it's the true price. If necessary, let's make an expert review. Let's invite experts from the expert review center, international experts. It's not exaggerated. I'm very calm. Few more questions about these real estates. Your father has and had an apartment in Yedinets, yes, to this day. Yes, he's living there. And starting in the year 2001, 2002, the apartment in Chisinau on Albishara Street, yes. My clarification question about this house, incomplete house that was sold in 2013. The purpose of it was to improve your family's living conditions, or was built for the purpose of selling it later? The apartment? No, construction of a house. Your parents had several real estates at the time. And building the house, did they start it for a commercial purpose? Because it's one thing when you sell a land plot or when you sell a real estate, as I said. So the income is totally different. And since you mentioned that your parents used some construction materials from another house, that's what I mean. Was it done for commercial purpose, or was it meant for a family, the house? I don't know. I don't know if they plan to do it, because It wasn't clear with my brother, will he come back or not? And it wasn't necessary anymore to keep it for the family. And it was clear that I wouldn't be going to the district to live there. My brother by that time has it for years. And maybe at the beginning they wanted to build it for their family, or maybe they were thinking that my brother would be living there. But subsequently, I think that wasn't necessary anymore. That's why they sold it in the condition that it had. And indeed, we did not have any evidence that it was a one-room apartment in Chisinau. With respect to the additional income, going back there, because I forgot to ask you that question. In the period when your father retired, he worked for several companies. What about his income, his salaries, let's say? What proportion? And if additional to that, those two companies, he was working simultaneously, and he also had that activity of selling at the market you mentioned. No, he was not selling personally, but okay, but declaration of a third person, or the purchase and selling of apples for a few years, or raising cattle for financial purposes. All of these activities, were they cumulative, or was it all they happening at the same time, or happening only one thing at a time? Well, for instance, honey, to this day he has 10 hives. I mentioned he used to have 50 from a family friend who unfortunately passed away. I wrote when it happened, like 2019, 2020. So out of 50 hives, he has 10, and there are other persons in Oknitsa district. So does he have any income from that? From 10 hives, it's not income, it's only for personal consumption. And the others, I said somewhere in 2007, 2008, until 2010, 2011. And you also told about raising cattle that was slaughtered. Was that to cover needs? Because we understand the realities of Moldova. For instance, one animal per year is for family needs, or more, or no, there were 3 animals. 1 pork, 2, maybe 3 swines and a cow. For trade, well, our family was not large. 3 family members. My brother, myself and my father, we did not have a huge need for food, and we have relatives in the countryside as well. And you know the realities from district centers. You have all the relatives are living in the countryside, and all the food stuff comes from countryside. I mean, it's more complicated in Chisinau maybe because it's 200 kilometers away, but when living there, everything's close. And your brother left for abroad when? 2000. 2009. 2009. I think like that. 2009. Maybe 2010. 2009. More than likely it was 2009. I see, thank you. Mr. Mikilionis, would you like to continue with questions about other aspects? You have the floor.
Yes, thank you, Ms. Chairperson. So let's move to the second group of questions related to the payment for the vehicle BMW 520D, model year 2013, and another BMW 520D X-Drive, model year 2017. So in your annual declaration submitted to National Integrity Authority for the years 2018, 2020, you declared the use of BMW model year 2013, indicating its value as 300 lei. According to information from the State Registry of Transport, the vehicle was registered in the name of your brother from 4th July 2018 and 6th of August 2021. Is this information correct?
Yes.
Thank you. In response to the first round of questions, you stated that the BMW model year 2013 was used jointly by you and your brother. During periods when your brother was abroad, your brother continued to contribute expenses related to the vehicle's maintenance and the completion of the necessary formalities. Is this information correct?
Partially, yes. I declared that it was I, him, my father, when needed, as needed.
Thank you. Could you provide additional documented evidence demonstrating that your brother was the main user of this vehicle, BMW model year 2013?
Yes, and all the documents and pieces of evidence were, I believe, presented already, and some of them were managed by the panel, and they are in the evaluation file that I have seen. So as regards to the financial capacity of my brother in relation to the procurement of this vehicle produced in 2013, manufactured in 2013, that was purchased, as you stated, in July 2018, that was bought when he returned after having been for about 10 years abroad working. He was in Canada, and I provided to the Commission his income statements, his income declarations for that entire period of time. Since the database was, I think, from 2012, had available information from 2012 through 2023. Additionally, I've also submitted the statements of a relative also staying in Canada since back in the 90s, and that relative was coming back annually to Moldova, and he would send some part of the money over through that person, who would then hand over the money in Moldova. So that, and then when my brother himself was traveling, he too was bringing about some money that was allowed as per the customs law without having to be declared. From 2009 through 2018, he has not been in Moldova in that period of time. He's only been in Canada. So through those relatives, he would send over money, not too much, from 2,000 to 5,000 in currency. It could be euros or dollars and so on and so forth. And when he was back in 2018, when he returned in 2018, until 2020, well, in 2020, as I stated, in 2018, in fact, he has become a Canadian citizen. He has acquired the passport since December 2018, and he's only been using the Canadian passport. All of his incoming and outgoing, his travel can be confirmed through that act. Only he does not have Romanian citizenship, and he used the Canadian passport since 2018 onwards. There was a question regarding other evidence regarding his travels. I couldn't have presented that. Only copies of his passport. And the Commission has also established, including in terms of availability of funds to buy that car. As you've stated, in July 2018, the car that I was using was sold. I can't remember the date precisely, but it has been sold. So it turns out that at that time, I did not have a car. He came to Moldova, and there was the grandma, the relatives that required some medical care. They needed to be taken to the doctors, and the mother, and there was some personal needs. So he took a decision quite fast and bought that car, taking into account the fact that we live nearby and the car is parked in the same yard. Upon need, we would be using it both. As regards the evidence, the insurances from 2018, 2019 that I submitted to the Commission, both of them, he has taken care of them and he has paid the insurance premiums. And I've seen in the files some information from the National Road Transportation Agency. There was some information regarding the vehicle fitness tests. I've seen that information, and it's again him appearing as the person being there. So he was the one who took care of that, and I speak of 2018, 2019. following 2020, from 2020 onwards, myself and my father, we were in a position to take care of those activities. When he was away, I could have gone, or the father could have gone for the vehicle fitness test or for the insurance, but my father was taking care of insurance, and I provided the documents for that, for both cars, the first and the second one. And 23, when he returned, from 23 onwards, the insurance would be addressed by him personally. He would take care of that on his own. And I also have a report on a contravention in 2024, a minor violation that he committed. So in person, he was here, and I provided supporting documentation confirming that he was using that car. But upon need, I would use it, provide the fuel, wash it. It's not excluded that I could have paid for fitness tests, or if my father would be given a call to take care of it. In terms of financial capacity, he had it. He had the financial capacity to buy the car. And out of the evidence that was annexed, there is documentation confirming that he was using that car. In the year 2020, he, as I said, he needed to address some private and personal matters. He went to Canada for that. Amid the COVID, there were travel restrictions, and then he returned as late as 2023 to Moldova. And in that time, as I've also stated in my answers to the questions, there was some opportunity, there was a possibility brought up to buy a newer car manufactured in 2017. I've gotten in touch with him. I've asked him if he had any interest in that whatsoever, if he had an interest in procuring such a car. The price was more or less okay. It required some refurbishments or renovation worth about 2,000 in addition, so that's why the price was a bit smaller, the one that was paid for the car. He agreed, and I had a power of attorney. In 2021, the car was sold for 300,000, and another one was bought for 400,000, if I'm not mistaken, maybe a bit more, that is about 20,000 euros. And further on, 2,000 more was paid for fixing the vehicle. And the second car was bought on the basis of a power of attorney.
So I would like to interrupt you. We will move to the second car later. So some questions regarding the first BMW vehicle, if it's okay. So my question is regarding the BMW model year 2013. So additional question. In your understanding, in your opinion, who was the main user of this vehicle, you or your brother?
My brother was the main user. The procedures regarding vehicle fitness tests, insurance, he was doing that. He was taking care of that. And there wasn't big need. I mean, we were not living far away from each other, so often I would go by foot. It was not a problem. 15 minutes, it took me about 15 minutes to be at work. And for traveling, for trips, longer trips. So, and by the way, I have also stated that in 2019, there was a travel of his to, he traveled to Romania. And in the evaluation file, it says that there was a green card issued in his name, according to the passport data. So that was confirmed, what I stated about him using the car. He was the one who was using it more. Well, we were using it upon need, if there was a need. For 2018, 2019, all of the procedures, anything regarding the maintenance of the car, he was taking care of that. Irman, the microphone, please, if you were speaking.
Thank you. So in which country did your brother live in the period 2018 to 2020? And could you provide any proofs confirming this fact of your living in that country?
in Moldova, and it's the same documents. There were the insurances and the vehicle fitness tests that he did. So he stayed in Moldova. 2018, 2019, he was in Moldova. Additionally, I provided copies of his passport, or his Canadian passport pages were scanned, and they are proof of that. In 2019, he had a trip. I've stayed it for about 2 or 3 months. He has been gone to France. I think in December he had gone to get the passport and he returned. So there were some trips he would travel, but not that lengthy. So 2018, 2019, he was mostly home. And there were just some trips that he spent a while, like a month or 2, he would spend elsewhere. But the longest time he was absent was in 2020, 2023, about half a year. That's when he was away from Moldova, but that was due to the COVID pandemic. He stayed over there.
Thank you. Where did your brother work in this period from 2018 to 2020? And what income did he have during this period?
To be honest, I cannot tell. Well, I do not know about it. I am not aware. I really do not know. But in general, did he engage in anything, any activity whatsoever for as long as he was staying here? Yes, as far as I know, he was up to something, he was doing something. I know that he pursued another education, he was taking some courses. I did not go into the details of that. I mean, he was living his life. I really don't know what to say. I know that he was up to something. I knew he took some courses. And for a while, he went for his second higher education degree. So he was doing something, but to be very specific as to what exactly he was doing, I don't know, and we weren't really talking that much.
Thank you. One BMW model year 2013 was registered in your brother's name. It was assigned registration plate which has previously been used on your own Mercedes model year 2005 during the period from 2011 to 2018. Could you explain why your previous car registration number was used on your brother's vehicle?
Well, let me tell you, in this regard, after the sale of that car, I had decided to keep the number plates. There is such a service, it can be stored away with the registration body. And I've annexed also information that according to a government decision and the nomenclature of services that can be provided by the Public Services Agency, storing, for storage you have to pay 100 lei a month for up to 30 days. So I saw no need, so that I don't pay 100 lei until I someday decide to buy a new car. I decided to allow, to yield these number plates to him. But upon sale, they would come back. Upon sale of the car, they would return to me, or they would be given to me for my car. Because as to the question as to why, well, I've used it for the old car, maybe a little bit of superstition. I had no issues with that car, so that is part of the reason why I decided to stick to these number plates. And as I said, since when in Moldova I was using the car was being used, so I felt no need to really look for a car and buy a car. The need emerged once the family was established in 2023 and a child came about, and that's when the Renault Kadjar was bought that my family is using, as I have previously described. So when I needed, when the need emerged for me to have it, my household bought in 2022 or 23, bought the Renault Kadjar, 2023.
Thank you. In response to the second round of questions, you stated that your brother purchased the vehicle using his income earned in Canada between 2010 2012. Is this information correct?
Can you repeat the years again, please?
Da. Da.
In the written response with the panel, you stated that your brother purchased the vehicle using income earned in Canada between 2010 to 2018. Is this information correct?
Yes, that is correct. That is correct.
And what income has your brother had in Canada from 2012?
Out of the information statements that he provided, it was shown that he had savings in Canadian dollars that was about 20,000 a year. That was his savings. That is including out of unofficial sources, that is tips. He would have some tips and some informal work. He was working formally, so he was formally employed, but as any other migrant working abroad, he would also work unofficially and he would get some tips. So out of what he said, because there was an additional round of questions and all the calculations and all the explanations were provided in that regard.
In your answers to the written round of questions, you also provided some supporting documents regarding your brother's income obtained in Canada during a period from 2012 to 2018 in the total amount of 124,269 Canadian dollars, equivalent to 1,710,086 lei, as well as explanation regarding his estimated living expenses for the same period in the total amount of 71,500 Canadian dollars, equivalent to 965,051 lei. Is this information correct?
Perhaps I do not have that information right here, but all of the calculations were indeed provided. So you mean the calculations that were made available by my brother, that my brother submitted?
Yes. It's the document that you submitted to the panel, and according to this document, we calculated your brother's income in this period, yes.
Well, then that is likely the case, but as I said, there was some unofficial income as well. So unofficial income for the informal work, including the tips that are also not subject to taxation. So there were calculations regarding that in his statements, and he has made some calculations, and he has shown his income, his expenses, his savings, and I have provided that in my response to the doubts, but along the way we can keep going back to that. Out of his calculations, about 20,000 a year on average. I mean, that amount that he would set aside includes the non-taxable or the informal income that was not subject to taxation.
Can you confirm that your brother had enough funds for purchase the BMW model year 2013? And what source of income was used for this purchase?
Well, as I've explained, the source that you have also mentioned just now, the money that he's earned out of his formal and informal employment while in Canada. Additionally, there were some sources, as the Commission stated, regarding dividends, where he was a founder since back in 2008. So he had funds. He had the funds, and it's rather about 300,000 lei, the equivalent of 15,000 euros. And in that many years, doing formal and informal work, it's quite plausible, quite reasonable for him to have acquired that big an amount. Additionally, if we go back to the need and the rationale, whether it was a reasonable purchase, the Commission claimed that as at that date of the procurement, he had another car, an Audi of 1979. But I've explained that that car, 79, manufactured in that time. In 2008, it was sold for a symbolic price, given as old as that. It was as old as that because it was about 20 years old when he had bought it in 2006, if I'm not mistaken, when he returned from the USA, because he's been away on work and travel programs, so he had some money set aside, and that was the first car that he just bought, to learn how to drive for practice. It was a very old car, and it did really not have an economic value. And in 2008, when he moved to Canada, that car too was sold for a symbolic price, and according to his statements, and as far as I can remember, it was simpler. I think it was on the basis of a power of attorney or of sorts. I mean, we didn't even know that, again, out of the rounds of questions and answers, I've learned that that car is still registered in his name. So it's really peculiar that there must have been some sort of a record, some sort of a power of attorney, and the buyer was supposed to re-register the car under their name. I told him about it, and I told him to go and settle the matter. And this is also proven by the answers provided by the Transportation Authority, the insurance company, because databases information available since 2012 onwards. There is no information as to him paying insurances and carrying out vehicle fitness tests by him, which means that, that car has even been, it's not even physically existing, it appears. It is not even running on the roads anymore. So we tried to look at it. In 2018, he was not actually the owner. He did not have that car. By that time, in 2018, I think that car was about already more than 40 years old. It's like a vintage car already. Indeed.
Thank you. On 6th of August 2021, immediately following the sale of the BMW model year 2013, you acted on behalf of your brother under a power of attorney and concluded a vehicle sale purchase contract to purchase another BMW model year 2017 for the price of 410,000 lei. The vehicle was registered on your brother's name, and this is information correct?
Not in my name.
In your brother's name?
Oh, yes, that is correct. In my brother's name, that is correct. I indeed had a power of attorney because he was not physically present in the country.
Could you explain when and how this vehicle was paid for? Whose financial resources were used to purchase this vehicle?
So, grosso modo, the money for the purchase of this car came from the sale of the previous car, and the difference was added out of the money of my brother to buy this car. He is the owner. To this day, this car belongs to him, and since 2023, as I stated, he has been the one taking care of all of the paperwork regarding this car.
Thank you. Was this BMW model year 2017 used by your brother? If so, can you provide proof of this fact?
So, since 2023, when he returned, as evidence of this fact, I provided the contract on the insurance, so this motor liability contract, third-party liability contract. And also there is a minor violation he committed in terms of road traffic and a fine in his name. So 2023, for that year, that what I just mentioned serves as proof of the fact that he was using it. And the statement of my father stating that the cars were his and my brother's statements under his own responsibility. So two statements corroborated by the information that I've already mentioned.
Could you specify in which country your brother lived during the period from 6th of August 2021 to 31st December 2023?
Well, not December. I think he returned in the second half of 2023. So that period that you're speaking of, he has been living in Canada in that period. He has gone to Canada due to the COVID pandemic, he was not able to return, so he returned in the second half of 2023.
Who covered maintenance expenses for the vehicle BMW model year 2017?
When he wasn't here, partially myself, partially my father out of his own money, so myself and my father's. So if my brother would ask my father to take care of some procedures, so my father would pay. If I would go to take care of some procedures, I would pay.
Prior to purchasing the BMW model year 2013, your brother received a total net income of 640,000 lei in dividends from the private company in 2016. Is this information correct?
Yes, it is correct. And there were internal sources indeed that the Commission has ascertained as well. So he had money, as I said, he had financial capacity to buy that car.
Are you aware how and where your brother used this income received as dividends?
No, I'm not aware, because that was his money. It's his business. And when it comes to his life, we don't really talk about it. So he's a little bit of a different type of a person. For having spent more than 10 years in Canada, his views have changed somewhat. So he doesn't really enjoy speaking about his personal, private life when it comes to money and stuff like that. So the money, he has gone abroad and then he returned back to the country. And as for the use, taking care of his own needs, and he did not decide till the very end, is he going to stay here? Will he go abroad? What will he do next? But that is his private affairs, and we don't really talk about what he does with his money, how much money he's got, and so on and so forth.
Thank you for your answers, Mr. Chairperson. I don't have more questions regarding this issue.
I, though, have some follow-up questions with regards to the vehicles used by you, but the de jure are registered, and one of them was already sold, but they were registered under your name, under the name of your brother. So when your brother purchased the first BMW, at that time you no longer had a car because you had sold it. How long has passed since the moment you sold the Mercedes that you owned and until the BMW was bought by your brother? If you remember, of course. I think the same year. I don't think it was too long. If it's the same year, then it must have not been long. I don't remember. I think it was about... it was not a long period of time. There was May 17 or 18, but if it was 18, it was May 18. And as Irmanta stated, July, so May, July, that period of time, if it's the same year. Now, I can't remember if it was 17 or 18. The vehicle, but I think it was 18 because certainly I wouldn't have gone a year without, so I couldn't have gone a year without a car, so most likely it was in the same year when he returned. that's when the car was sold, 2018, and the difference was about 2 months. Most likely it is that. So most likely it was 2018, and the difference of time, in terms of time, was 2 months. Because it's not such a long time since he returned, with regards to the procurement of this car by your brother, at that time, was he already in the country? Yes, he was. Who decided? I mean, if that would have been 2017, then I should have rushed to buy a car. But it was 2018, I sold my car, he came over, he was at home, and he needed a car anyways, and he bought it, and it means that, well, I had some needs, I mean, my grandma, to take her to doctors, but then afterwards he was mostly doing that. So he needed a car anyway. And you too, as you've mentioned, you too needed a car, because when you sold that car in 2018, the Mercedes, did you already have the intention to buy a new one, or were you already engaging in discussions with your brother regarding the new car? It was rather spontaneous, in fact. If that was May, in summer, he was looking for a car, and if he hadn't bought a car, then I would have had to think about it, because my grandma was not in a good health condition. She needed to be taken around. If he wouldn't have bought a car, I would have had to buy one. He decided to buy it already being in Moldova, or he made that decision before he came to Moldova. I mean, I cannot tell about his decision, but he might have had it in mind. And you haven't talked about his plans, as in he is allowing you to use for free a car that is not cheap. What do you mean for free? I mean, we're brothers. I too have had some merit, so to speak, in contribution until he left. He was a student. We were living together in that apartment until 2008 when he was a student, and I would help him out as much as I could until he moved he went to the US, and including at that time, because, I mean, he too has some moral obligations, so to speak. And additionally, initially, it was indeed very complicated for him for 10 years, having stayed in Canada, where the roads have all of these signposts and everything. Back in 2018, it was actually very complicated to drive in Chisinau. I just wanted to say that he was used to the way in Canada the roads were painted, so to speak, and it took him a while to get used to things in Moldova and the signposting on the roads. So in 2018, July, I think, when your brother bought the first car, we disregard the one that is since 1979. I mean, that was already gone. So speaking of the car, the BMW make year 2013, at the time when he bought it, and for as long as he stayed in Moldova, who was using the most the car?
He was my father, maybe sometimes when he was asked. So usually I was using, only when I was asking my father. When selling that car, who was the seller, you or your brother? De facto, he wasn't there. So he has already left then. When you sold this vehicle in 2013, the car from 2013, yes, I sold it based on power of attorney. I sold that one and bought the next one. So you didn't provide a copy of that power of attorney. I did provide it. It's because both transactions took place on the same day based on the power of attorney. So you sold the vehicle and purchased the next one based on the power of attorney, yes. So you purchased the next one. Who decided on the purchase of that specific second car, you or your brother? I suggested, he accepted. You are the ones who made the suggestions. I had the idea of the suggestion. If I'm not mistaken, in one of the question rounds, I explained that car shop where for maintenance purposes, there was an offer there, like, there's such a car, if you're interested. It has some issues, but it's good more or less. And I asked my brother, look, there's such a car. That one was made in 2013. This one is newer, 2017. Do you want it? And your brother accepted it instantly? Not instantly. Well, instantly. If you have an offer for a car that is better, newer, you are using the opportunity. And since 2023, so the market price was more convenient when you bought it. The difference was not much. Or was it an investment that you believe was good? The car is not that much of an investment. It's expensive, but over time the price is the same. You know, now with all market and over market fluctuation, the price is the same. It's an investment because it's a vehicle for which you paid more than 400,000 lei. I'm speaking about the second one. It's a serious investment. I'm not. It's sure it's profitable. The difference wasn't that big. I sold the other one 300,000 something, 300,000. Then you bought the second one 400,000, and there's 5,000 euros. Is there capital gain when you sell the first car? So you sold it for what you bought it. Nothing changed. No. 300, yes, that results from the declarations that I previously filed when purchasing this vehicle, because I declared to NIA that I'm using it, I think how often or something, in order to exclude any doubt. I declared that I was using, as I declared that I was using the Mitsubishi Outlander of my father. I used it for 3 or 4 times, but I still declared it. Exactly the same with these cars. I declared it to avoid future questions, to exclude some unclarity. With respect to the purchase of a second vehicle, so on the same day you sold the first one, received around 300,000, added some money. This money belonged to you or to your brother? His money. Did he leave cash for it? No, it's my father. I don't want to make it very public. Your brother's money are with your father? Where they live together, that's where the money is. A part of the money. No money. Well, okay, you use your father giving money. Among others, he knows where the money is, let's say. That isn't it more convenient for your brother, who is living for a significant part of time in a developed country with a banking system, very well-functioning banking system, to keep the money in a bank account and a deposit, or even in Moldova, and earn some dividends instead of keeping it like this? This is maybe used. It's also about commission, because in Moldova you need to convert the money and so on, and I think maybe the amount is not that large, so the decision belongs to him. The second contract, you acted there based on power of attorney. Yes, he wasn't in the country. It was 2021. So you acted on behalf of him? Yes, I acted on behalf of him based on the power of attorney. One more clarification question. You mentioned that your brother had some income, and that is also in the question rounds, had some income from a company in Moldova. The years 2016-17, I don't remember exactly. It was dividends from a company. Was that money kept in a bank account or not? I can't say. You know, after having lived in Canada, he had some other visions about his life. And you are not talking about... I mean, for him to give an advice, like, look, overseas, the things are like that. It's better to do like this, like that. Maybe you change your practice in Moldova as well, I think. What do you mean? Generally, things like the way of making transactions, of buying things, keeping money, concluding contracts with banks, and so on. I don't know. He has his visions and his reserves, and I understand that. When we talk in the family, we have a level of communication. But professionally speaking, weren't you interested how certain systems work abroad? Didn't you? I know them. My professional work, I know things better than he does. I understand. I investigated many things. You mentioned that in 2021 or 2023, you purchased another car, the Renault. It was at the same time when my child was born, part my money, and it's used by you or mostly by your wife? Mostly the wife, when needed, I use it. Now,
Deci
Al
acum
doilea
să
copil
înțeleg.
îl duc eu.
I am taking the second child. Now you're not using your brother's car anymore.
Sau Cate,
Occasionally.
posibil la, eu nu
Or
știu
maybe.
ultima dată.
I don't remember the last
Sigur,
time
la
I
un drum
took it.
lung e
For a
mai
long
comod,
road,
ceva ce e
it's
mai confortabil,
better to use that car. It's more
dar nu se minte
comfortable.
dacă din
But I don't
23
remember if since 2023 I took it. But where is it kept? In the courtyard.
Nu, dar este
Your?
între blocuri.
No,
Blocuri
it's
de cei de
in the yards because
blocul
the neighboring
apartamentul vechi,
yards.
poate să nu știu, este mijloc, este parcare.
There is a
Deci el, asta
parking in between the buildings and it's there.
Am înțeles. Încă o întrebare, dar stați.
One more question.
Ați luat cu răspunsul ăsta și mi s-a spus.
Da,
Give
de
me a
ce?
second.
Acolo poate să fie
Usually,
stabil, sau depinde, dar
well,
nu
it
când
can be in my yard, but it depends. He comes to me or not, but actually we are living in like two neighboring or almost neighboring buildings,
50 de metri.
50 meters away between the buildings.
Deci și-a fost decizia tatălui.
That was the decision of my father. Going back to the first question, that was my father's decision. He decided to buy it there because it was close.
Soția în ce perioadă a
Your
intrat
wife,
în concediu
when did she start her
prenatal și de îngrijire a
maternity leave and
copilului?
child care leave?
S-a născut primul copil.
You don't remember when your first child was born?
Actele se fac până la
I remember when he was born, but I don't know when the documents. The first child was born in January,
23.
January 2023, and the second
Și mijlocul de transport a fost
in August. And the vehicle was purchased when?
23 sau
In 2023 or in 2021?
Categoric nu, 23.
In 2023, for sure. After the child was born or before?
Bine, dacă nu vă amintiți.
Okay, if you don't remember precisely, I don't remember precisely, honestly.
Tot asta a fost
I can't recall.
prezentat și mai
But I provided all the documents. Probably it was after January.
Da, așa
nu mă duc.
I can't say.
întrebare
Such a question I
ca să
have.
înțeleg și eu.
Cred că
I think it was after.
Am înțeles.
I understand.
Ca să înțeleg și eu
One question I want to understand the rationale
hai să zic așa, fraților, pentru că nu
of
sunteți
brothers,
doar cu asta
because
de-
you are not the only one with such answers.
Fratele dumneavoastră
Your
este
brother
stabilit preponderent cu
is mainly
activitățile și
living,
viața personală,
working
viața profesională peste hotare.
abroad.
deja nu, domnul președinte, în 23.
Not anymore. Since 23, no. I was speaking about the evaluation period until 2023. So mostly he was abroad. He purchased one vehicle, he purchased the second vehicle.
Nu a investit
He did not invest money into some real estate that would be a much more profitable investment and less risky investment, given the way that
El se folosește de
those
aceste
assets
două
are used.
mijloace de
He's
transport
using these
mai
two
puțin decât
vehicles
dumneavoastră.
less than you
Sau le-a
are,
folosit mai puțin
or
decât
he used them
dumneavoastră.
less than you
Mare parte
did.
din
You
mijloace de
declared that the
transport a fost
first
utilizat
vehicle
de
was
dumneavoastră și mai puțin
mostly used by you, not so much by him. Not
Not
chairperson. I said in 2018, 2019 he was here, but for short periods of time. But in 2020, 2023, first half, yes, it was used by me because he was physically not here, and all the activity. When he decided in 2018 to come back to Moldova, it was the decision to become to be back in Moldova. He left in 2020
În anul 2020, deci, pentru careva nu știu.
for I don't remember some documents for some needs, and he had a problem coming back because of a pandemic.
Nu era de
So it wasn't.
Scopul cu care a plecat
The
peste
purpose for which
hotare a
he
fost de
went
a se
abroad
stabili la
was
trai
to
permanent sau-
live there permanently. Initially, I think so, because he was there for 10 years.
Asta și-am făcut referire.
That's what I am making reference to. Let me please now ask you the question. What was the economic rationale to invest money in a thing that is less profitable and it's risky as any vehicle? It can be involved in an accident and it can all of a sudden be of zero value instead of investing in real estate, given that he comes, as you said, he could have his own apartment since he had financial resources. So, from what I understand, he does not own real estate in Canada. No.
ce cunosc eu nu.
From what I know, he doesn't. He did not invest there, he did not invest here.
După mine, deci, mijlocul transport,
My opinion,
automobile sunt mijloc de transport.
cars
deci
are
investiții
means
pentru
of
a
transport.
păstra
They
capitalul
are
sau
Not an investment to keep capital or to grow capital. With respect to investment in real estate and so on, I don't know what his plans are here in Romania or elsewhere. I don't know what he wants to do. We're talking just about means of transport. Having this money and the possibilities, maybe it's a whim, it's just a desire to drive, well, not the most expensive car, but an average, not very, very expensive, but not cheap. He did not do the easiest work to get it. I'm just meaning it should be treated as an investment. Okay, let's not call it investment. I understand. It's quite a large amount that it was paid for it instead of investing it to grow the value. But he anyway needs a vehicle. Not if he didn't buy that one, he would have purchased another one, 5,000 cheaper. He anyway needed one. Give or take, so because he needed a vehicle anyway. About investment plans, I don't know what he plans to do. Where to invest, how to invest. Maybe he is investing and I don't know. Keeping secrets. Mr. Micheleonis, any questions from you? Please continue.
Thank you, Ms. Chairperson. So the next group of questions related to unjustified wealth. Firstly, for the year 2013. According to information available to the panel, in 2013 you had a high ongoing financial flow than your incoming financial flow, resulting in a negative balance in the amount of 646,757 lei. Your household incoming financial flow was 98,195,000 lei, and outgoing financial flow was 744,952 lei. In your written statement dated 16th of July 2026, you disagreed with the inclusion in the outgoing financial flow of 43,500 euros, which was used to replenish your father's bank deposit opened on 5th of July 2013. You also disagreed with the consumer expenditure for population amount established by the panel, namely 33,101 lei. According to your explanation, the CP should be 28,822 lei instead. How can you explain this negative balance in 2013?
Thank you. The negative balance is caused to the largest extent or exclusively by assigning to my expenses the amount of 711,456 lei in 2013, the money that resulted from the sale of the house that I referred to previously, 43,500. I just wanted that there were doubts about the source of that money in 2013. This money is assigned into my expenses, which in reality is not true, and that's why I tried as much as possible to prove, and I believe that I managed to provide conclusive, relevant evidence about the provenance and purpose of that money, and I think it's wrong to assign to my expenses the amount of 711,456 lei. Because my income in 2013 was 98,108 lei. Actually and factually, it's 98,195. Though what the Vetting Commission asks the amount of 43,500 euros, equivalent to 711,000 lei, I believe is not right. It should not be assigned to me, and I provided all the evidence. With respect to the disagreement with the CEP, the de jure difference found by the Commission, 33,101, I believe, given all statistics and filters applied when establishing the CEP, if we established only a natural person without filter of household, including
zonele și mai departe. Deci,
the area and so on,
în opinia mea,
in my opinion, 28,822 results, but that is not that amount. The important amount is the 700,000 lei, the equivalent of 43,000 euros, because that is changing the entire picture, the entire landscape radically, because if we exclude this amount, 43,500 euros, my balance, the difference between this minus 646, will have a positive amount of.
Suma aceasta a fost eronat mie atribuită. Deci,
I asked him to repeat the numbers. If we exclude the amount of 43,500 euros, the equivalent of 700,400,
atunci, diferența la mine solul
56, then my balance becomes positive because
venitul meu
my income was, according to the commission and according to 98,195 lei, and the expenses were 29,182 lei.
diferența îți primește
The difference, 69,012 lei positive balance. That's it, thank you. That is about year 2013. So I think that this amount, the amount of 43,500 euros was wrongfully assigned to my expenses from the sale of my father's real estate in 2013, which we discussed previously. Thank you.
Thank you for your explanation. So let's move to another year, 2015. According to the information available to the panel, in 2015 you had a higher outgoing financial flow than your incoming financial flow, resulting in a negative balance of 36,098 lei. Your household total incoming financial flow was 72,520 lei, and outgoing financial flow amounted to 108,618 lei. In your written statement dated 16 of July 2026, you disagreed with the inclusion in the outgoing financial flow expenses for finishing works related to the apartment located in Chișinău municipality, Râșcani sector, Bunăvestire Street, in the amount of 2,667 euros. Expenses for payments, fees, and taxes paid in cash in total amount of 13,437 lei. You also disagreed with the consumer expenditure for population amount established by the panel, namely 36,889 lei. According to your explanation, the CP should be 33,092 lei instead. How can you explain this negative balance in 2015?
Eu mulțumesc.
Thank you. With respect to year 2015, one of the amounts that was assigned to my expenses, 55,728 lei, I believe, was assigned in an unjustified way because the finishing works in the apartment on Bunăvestire Street, Râșcani sector, that belongs to Ion Gaina, were carried out by him. He incurred expenses of around 8,000 euros, as I declared in the question rounds. Now, altogether, during the repairs. Only the period 2016-2017, I incurred expenses of 3,500, that's equivalent of 60,000-70,000 lei. That was partial for appliances and furniture. So the amount in 2015, the amount of 55,728 lei, was wrongfully assigned to my expenses. In my opinion, if we divide proportionally the amounts 2016-2017, or if they are divided to 2015, 2016, 2017, then 70 lei at most should have been divided proportionately to these 3 years. That's why I believe that 55,728 is an exaggerated amount that was
atribuite la
assigned to my expenses.
aceeași
The same argument is about the consumption expenses, but the difference is not big here. It's just according to Vetting Commission, the CEP is 36,889 lei, but in my opinion, it's 33,092 lei. So, and one more comment here. I believe that the amount included as payments, fees, and taxes paid in cash in the amount of 13,437 lei. I did not find any documentary confirmation of these payments, and I believe maybe I did not calculate something correctly, or maybe there is an omission. So if we exclude the amount 55,728 incurred by my father for repair works, and the amount of 13,437 and the CEP difference, if we take it only 33,092, then out of total income that the Commission found by the Commission is 72,520 lei, my expenses are actually 35,665, but not 108,618 as the Commission found. So, and it ends up not in a negative balance of 36,000, but a positive balance of 36,866 lei. In my opinion, we need to do some clarification about this amount of 55, or my expenses are divided equally across all the years, or the amount of 55,000, which was assigned only to me, it should be assigned to my father, actually.
Thank you for your explanation. Let's move to another, the year 2017. According to the information available to the panel, in 2017, you had a higher outgoing financial flow than incoming, resulting in a negative balance of 92,082 lei. Your household total incoming financial flow amounted to 303,481 lei, and outgoing financial flow amounted to 395,563 lei. And in your written statement dated 16th of July 2026, you disagreed with the inclusion in the outgoing financial flow expenses for finishing works, purchase of furniture and household appliance related to the apartment located in Chișinău municipality, Rishkana sector, Bunăvestire Street, in the amount of 5,917 euros. You agreed to reduce it to 35,000 lei. You also disagreed with expenses for payments, fees, and taxes paid in cash in total amount of 6,227 lei. You agreed to reduce it to 1,934 lei. How can you explain this negative balance in 2017?
Thank you. The negative balance is mostly due to the Commission's including into expenses the finishing works for the apartment and the purchase of furniture and household appliances for the apartment in the Râșcani sector with a total amount of 123,234 lei. While, as I mentioned before, my expenses were maximum 70,000 lei. So, if we divide it proportionally to years 2016 and 2017, for the year 2016, we could only include the amount of 35,000 lei. With respect to my disagreement, as you said, expenses, taxes, fees, and other payments, you mentioned 600,227 lei. According to my calculation, I believe that this is mistaken because the real amount was 1,934 lei. These are two aspects that I mentioned. And if we exclude these amounts that I believe are exaggerated, then we have a different calculation. Total income found by the Commission, 307,482 lei, and the actual is 305,482 actual. The expenses that the Commission claims to be 395,563 lei, but according to my calculation, it's 303,036 lei. So the difference by Commission's calculation is minus 92,082 lei, but according to my calculation is plus a positive balance of 2,446 lei.
Îmi cer scuze.
I apologize. Even if, let's say, the Commission will take into account or look that, deem that my expenses were 70,000 lei, and which wasn't entered for 2016. If we add 70,000 lei for 2017 in the table that we have, then the balance will be higher, but still it covers the subject with the repair works. I mean, it closes, it covers the entire amount with the repairs. If the Commission accepts the amount that I declare, 3,000 to 3,500, that, for instance, that was not included in 2016.
Thank you. So let's move to another 2018. According to information available to the panel, in 2018, your outgoing financial flow exceeded your incoming financial flow, resulting in a negative balance of 206,196 lei. Your household incoming financial flow was 457,543 lei, and outgoing financial flow was 603,739 lei. And in your written statement dated 16th of July 2026, you disagreed also with the inclusion in the outgoing financial flow expenses for the purchase of vehicle BMW model year 2016 in the total amount of 300,000 lei, expenses related to professional trips abroad in the amount of 21,316 lei, and expenses for payment fees and taxes paid in cash in total amount of 28,100 lei. You agreed to reduce it to 62 lei. How can you explain this imbalance in 2018?
Thank you. The negative balance is to a great extent due to the fact that in expenses, something was included, such as the amount of 300,000 lei. That is the procurement of the car, the BMW make year 2013. And as mentioned, I believe that this is not fair because the actual and de jure owner is my brother, who had the financial capacity to buy this car. He used it, and there was evidence provided to support this statement. So I believe it is not fair for this amount to be assigned to meet my expenses. Furthermore, another amount as expenses related to professional trips abroad, 21,316 lei. This amount is to be taken out because that was related to trips abroad, and that is already included in retail payments identified on the bank accounts for the year 2018. total amount being 72,129 lei, and that too was included
Rubrica
in that category of expenses. This money came in as a result of a project,
twinning.
a twinning project,
De ce au fost
and that's why this money was included in that account activity using my card, that is retail payments, because otherwise it turns out that this amount was calculated twice. There's a duplication and it needs to go away.
și taxe după calcul.
As for taxes and fees, 62 lei, but it says 28,000 lei here. So that is
Eu,
either
din
I,
perspectiva mea, și
from my perspective and my knowledge, I have calculated it like this, and maybe there was indeed a mistake, an error somewhere.
prin urmare,
Therefore,
corectăm și excludem sume.
if we make calculations and we subtract this, the total income de facto, as per my calculation on the basis of the documentation, that will be 457,543 lei.
Comisia constată cheltuieli de 660
Expenses 63.
după calcul
So the expenses 663,740 lei.
Comisia constată
That is as the expenses found established by the Commission. According to my calculations, if we subtract the value of the vehicle, the expenses would be 314,386 lei and 28 bani. That is, the difference is a balance that would in fact be positive of 143,156 Moldovan lei, and not minus 266,197,000 as established by the Commission, not the 206,197 as established by the Commission.
Thank you. And doubts regarding unjustified wealth for the year 2023. According to the information available to the panel, in 2023 we had a higher outgoing financial flow than incoming, resulting in a negative balance of 78,421 lei. Your household incoming financial flow amounted to 1,443,782 lei, and outgoing financial flow was 1,522,214 lei. In your written statement dated 16th of July 2026, you disagreed with the inclusion in the outgoing financial flow expenses for international money transfer from your wife to her sister in the amount of 17,820 lei, and expenses for the purchase of foreign currency in the total amount of 700 euros. How can you explain this negative balance in 2023?
Vă mulțumesc.
Thank you.
Vis-a-vis de mijloace
So speaking of the funds
sumă de
of 17,822 and 20 lei, this was included by the Commission as expenses, international money transfer to the sister of my wife.
consider că mijloace
I believe that the funds belonged to the mother-in-law, and I provided evidence as to that and the statements to that effect.
rezidenta Italiei.
She is
Transmiși fiicei
she resides in Italy. She transferred that to her daughter living in the Russian Federation via my wife.
cu declanșarea
When the war started in Ukraine, the relationships with the Russian Federation, especially in terms of the banking field, they were severed, they were put on hold, stopped, suspended. So any other way to transfer the money, there was none. The money was transferred to Moldova, and then from Moldova onwards, my wife,
sisteme internaționale.
well, I guess she would use some international money transfer system such as MoneyGram or whatever. I don't know. It doesn't say which one, to the card or whatever. So in this regard, there were written statements from the sister in the Russian Federation and from the mother-in-law. All of the documentation in this regard,
Prezentate.
was submitted. And supporting documentation as to that, there is also proof of the fact that my mother-in-law had a source to have that financial capacity. Since 2000, she's been living in Italy. As for the 13,635 lei that the Commission assigned as expenses as foreign currency purchase, I think this cannot be reflected as expense because, in fact, that is a currency exchange. So out of what I already had in Moldovan lei, I just bought euros. So there was just an exchange from one account to another. Mine or my wife, I don't know exactly who this is about. But the money, these funds that were converted, they remained on the same account. They're part of the balance as of that year concerned. They were just converted. There was just an exchange. So I think they were incorrectly assigned to expenses. And there's another gap in the amount because the Commission included in savings held in cash, 5,000 euros savings in cash of my wife from previous years, 2012, 2022, added as shared savings to the amount already owned in euros, as at the average exchange rate of the NBM for the year 2023. It's only that that amount is included only in the expenses category, although that is an income in 2023 initially, and then it turns into savings in cash at the end of 2023. Therefore, for income 2023, the amount to be included is 98,215 in order to reflect a correct and mathematically logical result. It was only reflected as expense, not regarded ever as income, would not ever regarded as an incoming flow. So that's why that led to this sort of a discrepancy. So after these calculations, given these calculations, it turns out that total income reported and the one that was established by the Commission, 1,443,795. But according to the calculations, 1,542,000 lei. As for the expenses, according to the Commission, 1,522,215 lei, but in fact it was 1,488,137 lei and 50 bani. So the difference is, therefore, 53,873 lei. That is a positive balance. That is it.
So, Mr. Gaina, thank you for your detailed explanation. And Ms. Chairperson, I don't have more questions regarding this and other issues.
Thank you, Mr. Mikkelionis. Mr. Lebedinsky, if you have any questions? Now, Mr. Gaina, I too have no more questions regarding these matters. As for the differences between income, expenses throughout the years that were subject to the evaluation of the panel, we are to analyze, to have a look at these numbers, taking into account your explanations, including the ones provided in writing, the ones that were provided in writing to the panel. If we happen to have some other follow-up questions, we'll get back to you. Considering that we haven't looked into all of the documents you submitted, we might send another round of follow-up questions. If there aren't other questions from the members of the panel, I would like to thank you for your participation, for your explanations. Thank you for having participated in this very lengthy hearing, and if there's anything you'd like to say as closing remarks, you may do so now. Thank you, Madam Chair of the panel. I do have some closing remarks, and I count on, and I'm sure of the professionalism, impartiality, and righteousness of the Commission. I count on that. and I hope for that to be the case. Thank you and have a nice rest of the day. Thank you too. We wish you too the best of luck in your work. The panel is to analyze all of the information, and we'll be moving on to the final stage, that is the drafting and the approval of the evaluation report regarding you. Having said this, the hearing of Prosecutor Alexandru Gaina, Prosecutor and the Croatian Prosecutor's Office, has come to an end.